Good morning and welcome. Firstly, before I start with the meat of the meeting, just to offer apologies from Ruth Maguire, who's been taken unwell. So I, as Vice Convener, will be chairing today. So good morning, everybody. And I just want to sorry, I'm just been handed a script at the very last minute here and realised that we're talking about the pre-meeting here, so I'm just moving to the actual final meeting. So I welcome everyone to the 24th meeting of the Equalities and Human Rights Committee. We have apologies from Alexander Stewart and Gillian Martin and Ruth Maguire, who I have already explained, and I would like to welcome Linda Fabiani, who will be joining us later, who is a substitute for Gillian. Our first item of business is the second evidence session on the United Nations Convention on the Rights of the Child Incorporation Scotland Bill, or the UNCRC bill, as it is also known. We will hear from two witness panels this morning, and I'm grateful to all of the witnesses for their virtual attendance. Firstly, can I welcome our witnesses to the first panel? Bruce Adamson, who is the Children and Young People's Commissioner for Scotland, Kavya Shetty, who is the Head of Strategy and Legal at the Scottish Human Rights Commission, Rosemary Agnew, Scottish Public Services Ombudsman, Dragan Nastic, Strategic Lead, UNCRC, UNICEF UK, Scotland and UK Office, and Ellen Saga Shorholt, and forgive me if I pronounced that wrong. Oh, Shorholt, I've got a pronunciation guide here, lawyer at the Norwegian Ombud for Children in Oslo, also with UNICEF Norway. It's a big panel, so I would ask panelists to be succinct, and if you don't feel you need to add any more to the questions that have already been responded to, then please don't feel obliged to. I will begin. We'll move to questions in just a second. I would remind members that if your question is addressed to specific witnesses, please identify that witness by name. Otherwise, we'll work to the order in which I've just named the witnesses. Witnesses, if you feel, as I said, if you've nothing to add, then please. Once completed, I'll invite the next questioner and so on until the evidence session is concluded. We've got a lot to get through today in a limited amount of time. Very important bill, but I would ask everyone to be as focused as possible. And please, finally, can you allow broadcasting staff a few seconds to operate your microphones before beginning to ask your question or provide an answer. So I will begin with the first question, and that is that there is strong support for direct incorporation of the United Nations Conventions on the Rights of the Child into Scots law. What are your views on the Scottish Government taking this approach, the bill before us, and what are the potential benefits or disadvantages of this approach? And so I'd like to start with Bruce Adamson. Bruce.
Good morning. Fully and directly incorporating the UN Convention on the Rights of the Child into domestic law is the most important thing that we can do to ensure that children's rights are respected, protected and fulfilled. And this bill is a bright ray of sunshine in what's been a very gloomy year. And so I strongly commend the Scottish Government and the Scottish Parliament for understanding the importance of progressing this bill during the pandemic, which has shown just how vulnerable children's rights are. This is a really strong bill. It builds on an understood framework that we already know through the Human Rights Act, and it strengthens it importantly. So it has the legal compatibility obligation, but also the scheme and the other additional measures of implementation that are very useful in making rights real. I warmly welcome the approach to time limits, to the strike down and read down powers, and also the additional powers for my office to take legal action to ensure the right to an effective remedy is supported. And so, very importantly, this bill fully and directly incorporates, as far as is possible, within devolved competence. And so it brings all civil, cultural, economic, political and social rights contained within the Convention into domestic law. And that will lead to a real cultural change. We've seen it in other places, and it'll make rights real, particularly in relation to economic, social and cultural rights. There are some improvements we can make in the bill, I think, around interpretation, around the definition of public authorities, particularly on commencement, the role of the Parliament, and ensuring an effective remedy. But importantly, this bill sends a very strong message to children and young people across Scotland. I've been calling for this for decades, and I know that the committee's been hearing from children across the country, and there are thousands, as I have, celebrating this bill, putting their rights into law. The Convention on the Rights of the Child is special, and the progress on this bill is something we really need to celebrate. And the world is watching as we all celebrate tomorrow the 31st anniversary of the Convention on the Rights of the Child and World Children's Day. So the time is now for this bill. This is a good bill. There's some things we can do to improve it, but it is really something to celebrate.
Thank you very much indeed, Bruce. I'd like to ask Kavita Chetty now to answer the question.
Thank you. Good morning. As Bruce has just said, this bill is a highly significant and really most welcome step to progress children's rights in Scotland, and the Commission really warmly welcomes it. The advantage of this bill and the approach that it takes is that it significantly strengthens the rights of children and young people, and it does that both in law and also drives to do that in practice. It does it in a really twofold way, by ensuring that children's rights are part of decision making at all levels, but also that rights are enforceable by courts where violations occur. And it does this by taking a maximalist approach, so by directly incorporating the UNCRC, the first and second optional protocols, into Scots law in as far as possible within devolved competence. And it's this direct approach, effectively lifting the convention text and placing it on a legislative footing, that's really welcome, because what that does is it seeks to ensure that there's no unintended gaps in protection. And it also assures us that we fully secure the standards as set out in international law, and gives us scope really to evolve those protections over time. As the committee knows, the UNCRC is the most widely and quickly ratified international human rights treaty, ratified by 196 UN member states, and it's the objective of the treaty, as the preamble sets out, which also becomes an interpretative source to the rights in this bill, sets out that fundamental objective that children need to grow up with happiness, love and understanding, and they should have special safeguards and care, including appropriate legal protection. Again, as the committee is aware, multiple UN committees have called on the UK to incorporate the treaty standards into our domestic laws, and Scotland will be the first part of the UK to do that to this extent possible within devolved competence, and following in the footsteps of jurisdictions around the world, as we'll hear a little bit today, Norway, Belgium, Spain, Sweden, and paving the way, importantly, for the incorporation of other international treaty standards. So overall, and subject to some of the issues that we're likely to come to in the course of today's evidence session, the Commission's highly supportive of this very progressive legislation and the outcomes that it seeks to achieve. There are a small number of areas where the bill could be further strengthened, for example, in relation to the interpretation of rights, the definition of public functions to be carried out compatibly with the rights, and to both how and when children's rights and access to rights be considered in policy and decision making in an upstream way. I'm sure we'll cover some of those issues in today's session. I'd just also like to note that obviously the rights of all of us, children included, are highly interrelated and interdependent. And so the incorporation of all people's rights, not only children and young people, will be vital to secure and embed a human rights culture across society. And that's something that we really see that this bill paves the way for strongly going forward. The Commission is a member of the National Task Force on Human Rights Leadership, looking at taking that forward. And it will be really helpful to have coherence and alignment between the duties and obligations provided for in this bill and a proposed broader framework securing other international core treaties in a meaningful way. And we're mindful of that in the comments that we provide today in relation to this bill. So overall, the approach to this bill, direct, lifting the treaty text, maximalist in as far as it tries to be, to go as far as possible in devolved competence, is really, really welcome. And I think this bill and the approach it takes really is something that the Parliament can be proud of.
Thank you very much, Kavita. Can I bring in Rosemary Agnew now?
Good morning. Thank you very much for the opportunity to speak this morning. I'm not going to add to what others have already said in terms of improvements to the bill, but you asked us about pros and cons of this. And I think the pros are self-evident. They speak for themselves. In particular, the emphasis on the child as opposed to children as an amorphous group, as children are a vulnerable group, however you want to say it. And I think that's really important that the focus is on the child. There are a couple of other things that I think, rather than cons, I would regard as threats that I think we need to be mindful of. One of those is transition from childhood to adulthood. We've talked about definitions and a child up to the age of 18, but often those who need the support of public service, of help, need it beyond the age of 18. So I think in this context of an alignment and a cohesive approach, we need to think about that. The other thing that I think also is not a threat, but we need to be mindful of, is supporting public bodies to do this. Because what we've learned over the last year from incorporating new whistleblowing for the NHS powers is it's not just about process or policy. This is about enabling a culture change at the roots level. So my interest is very firmly in complaints and complaint handling, but what I recognise is that cannot be taken in isolation, and fundamentally it is the culture of appreciating the child in everything we do. The one other thing that I would emphasise that a couple of people now have mentioned is this definition of public authority, and I think it's very helpful to think of it as public function or public service. So you don't focus on the organisation, you focus on what they are delivering and to whom they're delivering it. So I think in terms of your first question, I'll leave it there because I don't want to take up time that others will add other things to, and we'll maybe come back to some of these themes later.
Thank you very much, Rosemary. I'm now bring in Dragan Nastic, who's strategic lead of the UNCRC. I'm afraid we don't seem to have audio from you, Dragan. Perhaps we can move to Ellen Saga Sherholt while we sort out your audio issues, Dragan, if we may. Ellen.
Good morning, everyone. I also want to thank you for the opportunity to speak to you today. It's an honor for me to present the experience that we have from Norway. In this question, I think I will just support what the others have said. It's very important with all this holistic approach that all the rights are taken into the law at once so that we don't have a fragmented approach. The rights in the CRC are combined in a holistic way, so they need to stand together. For the experience in Norway, I would say that the full and direct incorporation has been very successful. We have changed awareness quite a lot to see children as subjects of rights instead of an object that we should support, which is very useful for how we see children when we approach them with services, for instance. We also have much higher awareness in all levels of society, publicly, through the media. All the legal actors have quite a different approach now after the incorporation, which is very useful to see the children as rights holders. We have also seen that the authorities became much more committed to the rights than they were before. So I would say that it has changed the culture on how we view children and children's rights. And I would also say that you asked also about, I can say briefly about the challenges. What was the argument in Norway was that the provisions are too vague, and that they were aspirational, but what we have seen, they are not very different from other legal instruments, and at least not other human rights. Even the courts, the Association of Judges said in the hearing that we do this every day. This is what we do. We interpret legislation that is not so clear always. So that was one point, and there also was an objection that it should have budgetary consequences going into the superior mandates of the parliament, but we have not seen that in Norway. I can explain more about that later if it's... Thank you.
Ellen, thank you so much, and particular welcome to you from Norway. Can I just see if we can try Dragan again and see if we have his audio? Hello, Dragan, can you hear us?
Hello, good morning. Can you hear me?
Yes.
Thank you for inviting me. It is a privilege to be with you this morning. The United Nations Children's Fund congratulates Scotland on this excellent bill. We work in 196 countries and territories all over the world. And we have seen that in those countries where the Convention on the Rights of the Child has been incorporated into the domestic law, it has served and provided a platform for other legal and non-legal measures of implementation, and was instrumental to bring in rights home to children and duty bearers. Looking from an international perspective, the Scottish bill is indeed unique. First of all, you are fully and directly incorporating the Convention as defined and recommended by the UN Committee on the Rights of the Child. Further and more beyond that, this bill also has a package of active and reactive implementation measures. And in that sense, this bill is really unique from an international perspective. There's no other country that has gone that far in their process of incorporation. And so we are absolutely sure that the incorporation in Scotland will be a success and will lead to a better and more effective realization of child rights. The United Nations Children's Fund is very keen to work together with you in the implementation process. So there are many qualities and good things to say about the bill. There are no shortages or faults. There are some areas where the bill can be further strengthened, but it is an excellent bill. We congratulate Scotland. We have promoted and publicized this bill in all countries in the world. We very much hope that Scotland will now show the way here in the UK, because it is the first UK country to incorporate the convention, but it also will serve as the guiding light in other countries where the incorporation is on the agenda, like Denmark and Germany. So, bravo, Scotland. Thank you.
Thank you very much, Dragan. That was certainly worth waiting for. Dragan and Ellen both touched on my second question, but I'd like to expand it to the wider panel and go into a bit more detail. Is that Scotland is by no means the first country to incorporate the UNCRC. I wonder, in those countries that have gone before us, what can we learn from their approach to incorporation, and can it help to improve this bill? Can I go to Bruce first, please?
Thank you. I think this is an important point, that our bill is fantastic. It does go further than other places, but we're by no means the first country to be doing this. A number of other countries, through their constitutional systems, automatically incorporate as soon as they ratify treaties, and so have a different legal tradition. So we've got learning from them and other countries that are perhaps more similar to Scotland. And so, particularly when we look to our Nordic neighbours and Belgium, kind of our North Sea neighbours, there's some really good progress there. Just this week, I had a meeting of a conference of the European Network of Ombuds for Children, and the commissioners and ombuds from all of those countries were there. And what they spoke about was the cultural change that is delivered through the mechanism of incorporation. As Ellen said earlier, the changing view towards children, particularly around things like participation and decision making, particularly around things like children's rights budgeting. It changes the way in which we understand children's rights, and that's so important, and that's the thrust of this bill. The reason that we need the legal protections and the ability to take legal action is to help drive that culture change, but what it's really about is changing the way in which we see children. And so the examples that were given from other countries, and UNICEF has studied this in depth, and so I'm sure Dragan will be able to speak to that, is this real change about how children perceive themselves and how those in power perceive children. You see more efficient and effective decision making, because children's views and their best interests are more properly considered, and that leads to better outcomes. And so lots of really positive changes. And it really does speak to Article 4 of the Convention about the state's obligation to put in place all legal administrative processes to ensure that children's rights are realized, and also about using the available resources to the maximum extent possible. So it starts to change the dynamic about how decisions are made and how services are delivered in order to particularly focus on children's best interests, but also the big improvements that we see on children's participation in decision making. So it's all good news. And while we should be very proud that this is a very strong bill, we have got a lot of learning from colleagues across Europe and other parts of the world who are further along this journey than us.
Panelists, that you need not go into great detail if this is not your specialty, but we're keen to hear from all of you. So Kavita, would you like to add anything?
Thank you. No, I'll defer to my children's rights specialists and international colleagues on this important question. Thank you.
Thank you. Rosemary, is there anything you'd like to contribute on this specific question?
I won't repeat what Bruce has already said so eloquently. Perhaps just focus on the sort of things that I would like to learn from those who've gone before us. And this is sorry if it sounds mundane, this is about the practicalities, what people actually did, how they helped bring about culture change, how they supported children, parents and carers and public services to actually bring about that culture change and think creatively about how services could be delivered in a simplified way to encompass all the things that they were trying to achieve. The other thing I would be very interested to learn is how they measured whether this was successful. How do they know it worked? Because it's not just enough to say we're doing it, we'd also need to be able to demonstrate we're doing it well. And I'll stop there, thank you.
Thank you, Rosemary. And Dragan.
Thank you. The first thing to say is that incorporation itself has a great value and brings a lot of positive impact. Our research and observations in countries around the world show that in those countries where direct incorporation has taken place, as a result of it, awareness of child rights has grown, and the acceptance of children and rights holders has been strengthened. It is especially the case in those countries where a lot of preparatory work and consultations have been done around the incorporation itself. Sweden is a good example where the preparatory work, the consultations and passing the bill took several years and involved a lot of stakeholders. We think that the process of incorporation being followed here in Scotland very much builds on that positive experience of Scotland. There was a wide consultation last year, many stakeholders, duty bearers and rights holders involved in that. This dialogue continues, and thank you and your committee for this inquiry and evidence session. This will all contribute for better implementation. And here I come to the second point, the implementation of the incorporation legislation itself. We have conducted a specific research looking at all those countries that have incorporated the convention into their domestic law, either by ratification itself automatically or via a separate parliamentary act, and also those countries where major pieces of law reform have been done. That research, one key finding from that research is that in most of those countries, unfortunately, the incorporation was followed by stagnation, and the momentum has not been kept and followed with a range of legal and non-legal measures of implementation. So it is important to bear in mind that incorporation is not an end in itself, and that it must be part of a broader holistic strategy for promoting, protecting, and realizing child rights. And the main obstacles and difficulties reported through our research show to the need for better planning and coordination, more awareness, training, and education activities. Only that can lead to better awareness of child rights and a more robust infrastructure to ensure implementation and more effective realization of child rights. And here I would like to say that UNICEF very much would like to step our activity in Scotland and to contribute to effective implementation of this bill. May I mention our Rights Respecting Schools program in Scotland. 1,337 primary and secondary schools in Scotland are part of the Rights Respecting Schools program. 54% of all schools in Scotland are affiliated to our scheme, through which children not only learn about their rights, but they live their rights. They are aware of their rights, but also aware of the rights of their peers, and they respect it. Other members of this scheme are also other institutions like standalone nurseries, ASN schools, and children's homes. We would very much like to step up our program in Scotland and align it very closely with your implementation measures, so that we give our contribution and make sure that what we define as stagnation does not happen in Scotland, but that indeed this bill is followed, but a much more stronger and effective realization of child rights. Thank you.
Thank you, Dragan. And Ellen Zario-Sherhold, you are speaking to us from Norway, and obviously you go before us in this regard. So please could you answer the question about international examples and your own experience?
Yes, thank you. I guess I will be the one presenting more concrete examples for you at this question. I would say I agree very much with Dragan and the others that it's a very, very important step to actually incorporate, to make the whole CRC and take the whole convention into domestic law. That is the first very important step. And I think that what I have seen from your bill, it looks excellent. My main issue is to tell that take the whole thing. It's important because of the holistic and how they are looked. It's a very close connection between some of these articles, and they can't be separated. That is the first step. And then some of the benefits come for free because the awareness will raise. And especially among lawyers, we could see that they started to use the CRC as a tool much more, and also in the courts. That also raised the awareness among other services when they saw that, okay, here is a court order. It says, we have to speak to children before we decide what to do. So then it starts to drill out into the other services, but it's not enough. You have to have a strategy on how to actually benefit from this incorporation. What you should do is to increase knowledge. And of course, you have some literature like Tobin commentary from Oxford, but it's too difficult for people working in the services. So what we did in Norway was that the authorities gave us money to make a book that could be used and understood for the people in the services providing directly to children, kindergartens, schools, child welfare system, health workers. So that is very important. And also do trainings. We should have done much more training in Norway than we would have been further and better on the implementation side than we are today. So that is one of my advices. And also to implement it into the monitoring system. Like in Norway, we have the county governance. We also have an ombudsperson for public authorities. And these institutions should implement and look into how are different services applying to the CRC. That is important both to monitor and to do guidance on how to implement CRC and fulfill children's rights. The last, I would say that courts, it comes naturally from lawyers, hopefully, but maybe trained lawyers, and also complaint mechanisms should have trainings to how to understand children's rights, and of course use the tools as the general comments, for instance. They are very useful.
Thank you very much, Ellen. I'll now move over to my fellow MSPs. Before I do, I should advise everyone that we have an hour left with this panel, so we've got 10 questions to get through, so really keen to keep answers as succinct as possible, but very grateful for your input so far. So now move to Mary Fee.
Thank you, Convener, and good morning to all of our panel members. There are a number of questions I'd like to ask the panel this morning, so I'm going to try and group them together, so apologies if my questions seem rather long, but I'm keen to get through everything. The first is in relation to Section 4 of the bill on the interpretation of the UN CRC requirements. And I'd be grateful if the panel could tell me if they think that it should be expanded to take account of general comments and concluding observations and any other opinions and international human rights treaties. And do the panel believe that there would be any unintended consequences if the bill was amended like this? And the second question I would like to ask at the moment is on the duties on public authorities and the role of the court. Because Section 6 of the bill, excuse me, places a duty on public authorities not to act incompatibly. But it has been suggested that it would be better if the bill was strengthened by introducing a due regard duty. So I'd be keen to hear the panel's views on those two things, first of all. Thank you.
Thank you, Mary. Bring in Bruce first.
Thank you. I think those two questions cut right to the heart of how we could improve this bill. So I strongly agree with strengthening Section 4 in relation to interpretation. I often describe the UNCRC as the most beautiful legal document in the world. As Kavita mentioned earlier, the preamble starts with this idea that children should grow up in a family environment of happiness and love and understanding. It goes on to set out all of the obligations to support families, to make sure that children can thrive. But it is also a 31-year-old treaty, and so it is important that we understand the rights in context. And so there's a lot that we can do to strengthen this. As Ellen said earlier, judges interpret law every day. This isn't a challenge for judges, but it is useful for us to add in additional guidance for how to understand the treaty in modern context. And the Vienna Convention on the Law of Treaties sets out that interpretation should be in good faith in accordance with the context and the objective and purpose of treaties. And the UN Committee does an amazing job in setting that out through things like general comments, which are the interpretive guidance on specific elements of rights, or concluding observations, which are specific to states, which again we can learn from. Also, Optional Protocol 3, which the UK has not yet ratified, which provides a communications mechanism, so cases can go to the committee for determination, and so those decisions, I think, would provide very important jurisprudence to the interpretation, and also some of the work that the other treaty bodies do as well when it speaks to how we understand and interpret the convention. I think would all be useful, and I think that should be strengthened. I think a good example perhaps of this is the general comment that's currently being produced on children's rights in the digital environment. This was the Network of Ombudsmen for Children last year, and the convention was drafted before the internet was really widely available, certainly before kind of social media. So this general comment will help us understand how to interpret the right to privacy, to protection, to access information, to education. So we do need that. And also general comments themselves kind of go out of date over time. So we need to be able to keep up with the living instrument that is the convention. So that's really important. It's also very important that the legal community has access to this and knows that that's the approach that should be taken. And so it's important to be on the face of the bill to instruct that. Because one of the things that judges in other countries have told me with a sense of frustration sometimes is the lack of arguments. When it's not expressly on the face of the bill, the legal community can sometimes be slow at making some of those arguments and properly understanding. So it's not just to support the judiciary, but also the legal community and children themselves understanding that the convention needs to be interpreted through the aid of these additional things that we could add in on the face of the bill. So I strongly support that. In relation to public authorities, in terms of clarity, this is around private-public, or you asked about the due regard as well.
Due regard, I'll come on to public authorities in a moment, but currently the bill as it is drafted contains an obligation to act in a way that's not incompatible, but the bill could potentially be strengthened by putting in the bill a due regard duty.
And I think, thank you. Yes, and so we've got the experience in Wales where they've led with the due regard duty. I think the important thing for me is that we've got the strong acting compatibly duty, and I think that does drive legal change. I think that's the really important thing, that we have the Holland Convention in, we have the duty not to act incompatibly. I think that will drive change. I think a due regard duty is perhaps a useful addition, but it shouldn't be seen as in any way as a substitute for the really important legal duty we have not to act incompatibly. And I think even in that, in and of itself, is enough to drive that change, because you need to put in place mechanisms like impact assessments and other things to ensure that you deliver on that.
Okay, thank you.
Okay, and can I bring in Kavita, please?
Thank you. Yes, so with regard to Section 4, the Commission strongly believes that this does need to be built on and strengthened to ensure that we keep pace with those higher standards of protection internationally. I think one of the most compelling advantages of the direct incorporation model taken by the bill is that the formulation of the rights themselves is identical to that of the international treaty, and so it's identical to that of those directly incorporated rights in other jurisdictions around the world. And so that means that there is this rich source of both international and comparative sources of guidance on the rights, and that really does sort of put flesh on the bones and give meaning and content to the rights for both public bodies and the courts. And as it stands, I don't think that the bill really capitalises on that advantage by directing courts to these sources of interpretive guidance. And we're really strongly of the view that to fulfil that ambition of the CRC being that gold standard in children's rights and it keeping pace with those developments in international law, being that living instrument, that very direct link to international guidance on the interpretation of the rights needs to be there. I'd also say the domestic courts are quite well accustomed to drawing on international sources to aid interpretation. They've obviously done it for a long time with the Human Rights Act, taking account of the European Court of Human Rights case law, and they would do it again with regard to guidance from elsewhere. And we recognise that, of course, these general comments, they're not binding sources of law and they're not drafted as binding sources of law. We do recognise that, but they really do provide an invaluable and authoritative interpretive analysis to give substance to the rights contained in the bill. And again, courts are equipped to take those non-binding sources into account and give them appropriate weight in their reasoning. And we've already seen that in recent years, how courts have already had regard to unincorporated treaty provisions and general comments as important sources of law and guidance. So we saw that, for example, the Supreme Court case challenging the benefit cap. The court cited the UNCRC, the best interests of the child, and explicitly referred to General Comment 14 of the committee as authoritative guidance. But in saying that, it's not a routine approach for courts as it is at the moment, and I think appropriate signposting for courts on the face of the bill would then be really, really welcome. The First Minister's Advisory Group on Human Rights Leadership, which was advising on a broader framework looking at other international treaties, particularly International Covenant on Economic, Social and Cultural Rights, recommended that there should be an obligation on courts to have regard to international law, and that included the UN treaties, the treaty body decisions, general comments and recommendations, and as well as comparative law. Sort of a further comment on that, I would say it is important to note here the distinction between placing an obligation to have regard to these sources, which doesn't obligate courts to consider those sources as binding, but merely to take them into account. But it does ensure that there's that strong connection, as I say, between the rights here in Scotland and that evolving international framework. In terms of unintended consequences, I really think the biggest risk here is the unintended consequence of not doing this, and that we end up with rights in this framework which are just not aligned with those rights internationally in other jurisdictions around the world. In terms of the second part of your question, so we actually have two sort of issues with the framing of the duties here, and one is around the formulation and one is around the framing. So it's really welcome, of course, that we have this duty to not act incompatibly, and that's great. But a key policy driver of this bill is to secure that rights-based decision-making in that upstream way, so embedding children's rights into policy and lawmaking upfront. One of the ways the bill seeks to do that is through the Children's Rights Scheme, the reporting duties on public bodies, but particularly with impact assessment, often that will only be directed at where there's an actual policy decision being taken or something being considered. And what I'm not convinced it achieves is necessarily pushing that proactive consideration of opportunities where children's rights can be advanced. And I think that's particularly important when you're thinking about rights of a socio-economic nature, like the rights to housing, food and health and so on, because these rights require positive steps to be taken to ensure that they're fulfilled. They require to be progressively realised, so improvements to be made over time. So we think the bill could potentially go further to ensure that those underlying obligations, those proactive positive measures, are better understood by public bodies, to building human rights into their decision-making, children's rights, and their priority setting and their budgets. And there are different ways to achieve that and drive through that change. You could do that by having an overarching obligation to respect, protect and fulfil the rights on the face of the bill. Another way to do that would be to profile that progressive realisation duty more strongly. But a way that would be more familiar to public bodies would be to reframe and differently articulate that duty and include that due regard duty. Because at present what the bill is, it takes that Human Rights Act model that we have set out in Section 6 of the Human Rights Act, where it's unlawful for a public authority to act in a way that's incompatible with the rights in the ECHR and Scotland Act. We've previously seen that both the First Minister's Advisory Group on Human Rights Leadership, as well as the Children's Commissioner and Together proposal around this bill, had that dual duty of a sort of compatibility duty, as well as you say, that duty to have due regard. And I do think that approach provides clarity as to the obligation of conduct or process, ensuring that there's rights-based decision-making in that due regard duty, as well as those of result.
I'm really sorry.
Yeah.
Kavita, sorry to stop you, and it's fascinating stuff, but I'm just conscious of our time and we have to get through all the panels. Rosemary, can I ask you if there's anything you'd like to add?
Points. One is in relation to the Section 4, it's not just the judiciary and public bodies this would benefit. Children are often involved in a range of other things where decisions are made about them or on their behalf, such as children's hearings. And the more advice and explanation and interpretation there is, I think can only be a good thing. The other, as regards duty, what I would observe is trying to show that you are doing something that is not incompatible is quite difficult. And I think the clarity and positivity about demonstrating what you are doing is probably more helpful for public bodies. So I'll stop now.
Thank you very much, Rosemary, and thank you for your brevity. And Dragan, if I can bring you in.
I also think that the section on sources of interpretation should be extended to include not only the products of the UN Committee on the Rights of the Child, but actually also general comments by other UN human rights monitoring bodies. And I refer you to the submission by Professor Eva Nolan, which explains importance of those products and for better interpretation of the convention. The policy memorandum itself actually recognizes the value of these sources of interpretation, but says that because they're not legally binding, it was decided that they shouldn't be given special status. I think that it is a way out, and that these sources could be mentioned on the face of the bill without necessarily giving them any special legal status. And I would like to point to two examples from abroad, a positive one and a negative one. A positive one is Sweden. The Swedish government, the Ministry of Justice, produced a guide on interpretation of international treaties, and especially this convention, specifically for judiciary. That is not a statutory guide, it's more a handbook or manual, almost 200 pages long, that will help Swedish judiciary in their training, but also in using the convention when they decide on specific individual cases. And the policy memorandum here in Scotland does mention that the Scottish government do intend to produce a number of non-statutory guidances, and so either that tool or maybe through child rights scheme could be used to extend sources of interpretation, but it is very important to do so. And I would like now to point to a negative example from Iceland, where the incorporation bill didn't contain any proactive measures, and indeed following the incorporation, the implementation was a little bit slow. And even the government official these days tell me that the level of knowledge and awareness of the convention and child rights amongst the judiciary is still low, and that's why one of the reasons why the convention has not been widely used by the judiciary. So it is important that this section is extended. And very quickly, just one line about due regard duty. The due regard duty is a positive measure, but the Welsh government took that option because they couldn't incorporate the convention. They would have done that, but incorporation of international treaties is outside the powers of the Welsh government and parliament still. So the due regard duty was their maximalist approach. But as Bruce says, this Scottish bill has a number of proactive and reactive measures which I am sure will ensure compatibility and proactive implementation of the convention. Thank you.
Thank you very much, Dragan. And Ellen, if I can come to you finally and bring back Mary Fionn after that.
Yes, very briefly on the Norwegian experience on general comments. It's very important tools, both to interpret and to understand and to apply the rights. And as is already said, that the document starting to get quite old and it will not be renewed. So these interpretations by the committees are important. In Norway, the general comments will be preparatory work, which means that they don't have any legal status, but they will be taken into account and applied when courts interpret the rights. And Supreme Court has considered the weight of the general comments several times, and this spring they concluded and said they consider them to have great weight when they interpret the rights in court cases. And the general comments is also very important tools for those working with children, especially the one on children's rights to be heard and the best interest of the child. They are very important tools that show how to do this in practice. Thank you.
Thank you very much, Ellen, and thanks for your brevity as well. And please can I have Mary feedback, because I know you've got more questions, Mary.
Yeah, thank you, convener. I have two further questions, and the first of those questions is around public authorities, and it's something that all of our panel members have touched on in previous answers. So I'd be grateful for the panel's views on whether or not they are content with the definition of public authority, and if they are not, what do they think needs to be done to strengthen that definition, and how should it be changed?
Okay, thank you very much, Mary. Bruce, can I bring you in?
Yes, I think this is a really important point. We do need to strengthen this. The intention is to make sure that children's rights are always protected, and we need to ensure against the privatisation and opting out of those protections. And General Comment 16 from the Committee on the Rights of the Child is very clear about this, is that states aren't exempted from their obligations by outsourcing or privatising. And so it's important that that protection's in there. I do understand the approach the Scottish Government's taking here, following the very familiar Human Rights Act model, but we know from the jurisprudence on that, and again, you received some very strong evidence last week on this point. And so, and also I would point to the Scottish Human Rights Commission's written evidence and Just Rights Scotland's written evidence, I think, which covers this point really well. And so, I would associate myself with saying we need to strengthen this, and a lot of this work's already been done. The Whale and Birmingham case, the dissent from Lady Hale on that, I think is very instructive, and the work of the Joint Committee on Human Rights. But again, I would associate myself with Dr. Boyle and Andy Searle's comments from last week, because I think that there's a very easy way forward here. But the key point is that the way in which the Human Rights Act provision, which is the same as this, has been interpreted, has narrowed it, which means that children would miss out if we don't change this definition.
Okay.
Thank you, Bruce.
Thank you.
And Kavita, and apologies again for cutting you off mid-flow. Last question.
No problem. So with this question, sorry, I've probably got more to say on this question also than other areas that you'll want to cover. But as the Children's Commissioner has just said, the approach taken in the bill here is the same as the Human Rights Act, where a public authority is defined as including any person whose functions of a public nature. But we know that Human Rights Act definition is being beset with difficulties when interpreted by the courts, and we really do think that it needs further consideration and alternatives fully explored. As Bruce has already said, it's a well-established principle of international law, including explicitly in the UN Committee on the Rights of the Child General Comment 16, that the state can't divest itself of its human rights responsibilities by outsourcing or delegating those responsibilities. So I think if Scotland's to fulfil its international obligations in the way that this bill intends, it must really ensure that those accountability gaps don't persist through the contracting out of services not caught by that definition provided for in the bill, and ensuring that they're brought within scope where services are outsourced to private or voluntary sectors. And I think the children's sector has flagged that there's a number of areas where that might happen, for example, in relation to private housing providers, childcare, private foster care, private schools, for example. And as I say, the court's interpretation of Section 6 of the Human Rights Act, which is mirrored in this bill, has created a lot of uncertainty, really, as to the situations where the Human Rights Act applies. And that uncertainty over the application and the scope of the legislation, it creates unintended and unequal outcomes for individuals. It undermines that whole vision that human rights need to be central to public service delivery. And for those involved in the delivery of public services, whether they're a core public authority or a private party, really need to be clear what their obligations are to accept and implement them. So it does need to be improved. We think that further clarity can be provided through a strengthened definition, potentially through guidance, potentially through regulation. And by doing that, it will mitigate against those unintended accountability gaps. I won't go through all of the sort of the case law history of this now. But as I say, the approach the courts has taken appears to be really in direct conflict with the passage of the Human Rights Act bill through Westminster. And the Joint Committee on Human Rights have been really concerned about this at Westminster. They've looked into it twice. They've done 2 inquiries into this issue, one in 2003-04 and one in 2006-07. And in their reports, they show several options to deal with the situation. And we think that there's probably a mix of those options that could be taken to strengthen the approach taken in this bill. As I say, firstly, strengthening the definition. They suggest alternative wording with explicit connection between the functions that are being performed by the body that are pursuant to a contract or some other arrangement. And they also say it's possible to look at guidance or even regulations, which provides further clarity. For example, looking at the type of functions, as I say, that are being carried out, and a connection between the service. Critically, in that guidance, I think a connection between the service that's being provided and the rights that are to be protected in the bill, and that would be in line with international law. There are criteria set out by Lady Hale, as referred to earlier, in the dissenting judgment in the key case in this area, MYL, which provide guidance as to what could constitute a public function. We think that could be worked with, as I say, into regulation or into guidance to provide more clarity on this issue and avoid unattended gaps in accountability. Thank you.
Thank you.
Thank you, Kavita. That was very helpful. And Rosemary Agnew, if I can bring in up next.
I will be brief. I agree. I think there needs to be more to define this. A couple of observations. It is important to focus on the function, but equally there has to be a focus on the obligation. I think that was the phrase Bruce used. And the obligation needs to follow the child wherever they are receiving a service from. So in designing these services, in defining this bill, I would be asking the question, is the child's right as strong now, and is the protection as strong now as it was if a public service had been delivering it directly?
Thank you.
And I'll stop.
Dragan? Thank you very much, Rosemary. Dragan, do you have anything to add on this question?
I very much agree with everything Bruce and Kavita says. What I would like to add to this, that here the duties go much wider than just ensuring that children have a redress and are able to take a legal action against public authorities or anyone else providing a function, public function for children. Article 3, paragraph 3 of the Convention on the Rights of the Child establishes obligation of the state party to set standards in conformity with the Convention and to ensure compliance by appropriate monitoring of all institutions, services, facilities, and providers. And so there is a duty there not just to enable access to justice, but actually to set standards, to set up permanent monitoring mechanisms, and to do regular inspections of all these public authorities and private providers. I will just refer you to the general discussion day of 2002 by the UN Committee on the Rights of the Child, specifically just on this topic, and a guide and recommendations provided, put forward by the UN Committee on this very subject. And by the way, one more example of how important these general comments and other documents of the UN Committee are for effective implementation of the Convention. So I think these duties and obligations should be and should find their place either on the face of the bill or maybe through some non-statutory guidances, child rights scheme, as Kavita mentioned, but definitely they should have their place. Thank you.
Thank you, Dragan. And finally, Ellen, would you like to add anything to this?
Yeah, just say very briefly that we don't have this discussion in Norway, that as long as private services deliver services on behalf of the officials in Norway, the officials in Norway are bound to secure that they follow the CRC. So, and also as a human rights lawyer, I would agree with Kavita on her arguments here.
Yeah, thank you.
Thank you very much. Mary.
Thank you, convener. And my final question this morning is on the courts and tribunal system, because it's the existing courts and tribunal system that will be delivering the judicial, too early in the day for me to say, judicial remedies in the bill. So does the panel think that the existing court and tribunal system is accessible to children? And if not, are there any changes that we can make through this legislation to make them more accessible? And how can we ensure that the remedies that are applied will actually be effective?
Thank you, Mary. Bruce.
I think this is really an important point, and the example that was given earlier about judicial instructions, we do have a bench book in Scotland. There's a lot of work that's done by the Judicial Studies Institute and others to make sure that that the judiciary at all levels is properly up to speed on things, and so that's very useful. And again, there's already been discussions and work by the Judicial Institute on this. Judges, as others have said, are already very used to the interpretation of international law, and so that's very useful. I'd also point to the work done by President May Dunsmuir on the Health and Education Tribunal, and some of the work that I've been doing, particularly around additional support needs, and the new suite that was in fact opened, that was designed by children, for children. And so there's a lot of really interesting work that's going on about making sure that we can have child-friendly justice and access to an effective remedy. And so there's a lot that we can learn from, but the starting point is a bit of a low one, I've got to say, is that our mechanisms for justice are designed by adults for adults, and they're even quite intimidating for adults, to be honest. And so making sure that children who are in a position of having their rights breached are able to access it is going to require significant change. We have seen some really good practice, though, in Scotland, which is really, really useful. And again, some of the work that the Children's Hearing System's doing. So there's some real positives, but we've got a very long way to go. And the important thing is getting children and young people to be part of that design change. But we've got a long way to go to deliver child-friendly justice. And again, I'm very aware of time, but in a number of the written submissions, we've talked about what an effective remedy looks like and all the different elements of that. And so perhaps I'll stop there. Just in interest of time, but an effective remedy involves lots of different things. What I'd look to see from this bill is quite a radical change to the way in which the courts and tribunals work in order to make them more accessible to children and young people.
Thank you.
Thank you, Bruce. Over to you, Kavita.
Thank you. This is another meaty question, and as Bruce has said, we know that children, and not only children, people of all ages across Scotland face really significant barriers to accessing justice in its fullest sense. And in international law terms, remedies for violations are expected to be accessible, affordable, timely, and effective, and they encompass not just judicial remedies through the courts, but also administrative remedies. And no doubt you've heard from many young people themselves about how our current system doesn't provide really for this, and routes to justice can be convoluted, hard to find, lacking in support, slow and expensive. And the UN Committee on the Rights of the Child pointed out in General Comment 5 that for children to access justice, they need child-friendly information, advice, advocacy, support for advocacy, access to complaints procedures, and access to assistance. And I saw in your evidence last week the extent to which people were alluding to the current system having evolved considerably over recent years, for example, children's participation in legal processes, but it does still fall really short of being child-friendly, and colleagues from the children's sector will be able to speak to those issues better than I can. But I do think this bill still does provide an opportunity to sort of help us to continually evolve and improve and build on our redress system to meet the needs of children. And one of the ways that we think that could be done through this bill might be to ensure that the children's rights scheme itself asks for more detail to be set out on access to justice support for children and young people and what's being done to advance that. So, for example, how child-friendly complaints are being advanced, legal aid, the resourcing of children's access to legal assistance is being improved, how services for vulnerable children like care experienced children or migrant children are being supported, and that could be one of the things added to the scheme. And it can also be addressed, of course, through guidance to public bodies on accessible and available information for children and young people, and include that as part of their reporting duties. We do think there's an opportunity there. In relation to the second part of your question, I won't go into this in a lot of detail now because it's a huge question. The right to an effective remedy, not accessible but is a cornerstone of human rights. I won't go into the remedies that are currently there on the face of the bill. One thing that I think it is worth saying is that we do think, because of the nature of the types of challenges that will be taken, those systemic issues, those issues of a socioeconomic nature where there's multiple victims, multiple responsible parties, that we do potentially need to develop a broader range of remedies by the courts over time. And I think Dr. Katie Boyle talked to this somewhat in her evidence last week. One of the things that we would look at there would be the development of structural remedies through, for example, structural interdict to address systemic issues. Essentially, that's where a court gives a specific direction to a public body to ensure compliance, so that the violation isn't perpetuated for others, and the court might even take a supervisory role in overseeing the implementation of a judgment. I don't have got time to go into that in any more detail here now. It is something that the National Task Force on Human Rights Leadership will be looking at in more detail about how we can evolve those types of remedies over time. Thank you.
Okay, thank you.
Thank you, Kavita. And I would say, and this goes for all panellists, if you'd like to expand on any of your answers today, then you are more than welcome to write to me. Can I bring in Rosemary Agnew?
Okay, thank you. I'm not going to repeat what's already been said. A couple of observations on this, though, and this is in relation to remedy, is if one of the things at the heart of this is children being listened to, and listened to in their words, not our adult interpretation, then I think we have to be much more open to remedies being resolution-based and involving children and listening to what they think the remedy should be. I would also very strongly support Kavita's point about structural changes, because like any complaint system, what we need to do is learn from it for the benefit of all. So I'll stop there in the interest of brevity.
Thank you very much indeed, Rosemary. And can I bring in Dragan?
Thank you. Kavita has beaten me. I was going to suggest the very same thing, that access to justice is included on the list of the things to be addressed, the child rights scheme, because indeed children's special and dependent status creates real difficulties for them in pursuing remedies for breaches of their rights. And so states need to give particular attention to ensuring that there are effective child-sensitive procedures available to children and their representatives. I would like to give here a good example of Wales, where the child rights scheme produced in 2012 gives a lot of attention and space to the issue of access to justice. There are two separate chapters in that scheme dealing with this issue. There is a chapter called "What Can Children and Their Representatives Do if They Think that the Ministers Have Not Respected and Followed the Due Regard Duty." And that chapter then lists a number of available avenues, legal and non-legal, to take an action. And then there's another chapter called "What Support Can Children Access to enable them to take an action." And this chapter very much deals with very specific mechanisms in Wales for child-friendly information, advice, advocacy, support for self-advocacy, and access to independent complaints procedures. And so that the child rights scheme in Wales served as a wealth of information with this regard and helpful guide, but also served as the basis from which then Wales continued to develop and expand child-friendly mechanisms. And so I think this is worth of considering to also follow in Scotland. Thank you.
Thank you.
Dragan, and finally, Ellen.
I'm afraid I don't have any good examples or very little, so I will just give the floor to someone else.
Okay, thank you very much for that, Ellen. And Mary, I take it that was the end of your questions?
Yes, thank you, Convener. I'm grateful to the panel for their answers. Thank you.
Thank you very much. In which case, I'd like to bring in Fulton McGregor.
Thanks, Convener. I've got a few areas to go through, Convener, so I would say to the panel that not all panel members need to answer every question if you feel that issues are already covered, so that we can get through these. Just following on from my colleague Mary Fee's line of questioning there, I wanted to ask about the subject about who can bring court proceedings. Section 10 specifically empowers the Children's Commissioner to raise court proceedings in respect of the duty in public authorities, and more generally Section 7 of the bill says an individual or organisation can raise court proceedings in respect of this duty if they can demonstrate sufficient interest. I'm wondering if the panel are happy with this overall approach, including the government's policy intention in the wordings of Section 7 and 10 of the bill. And I suppose the best place to start there would be Bruce, who I'm assuming will be welcoming of this aspect of the bill.
And your assumption is absolutely correct. I think in relation to Section 7, the panellists last week, I think, covered that really well in terms of how sufficient interest works and the growing understanding of the opportunities there. So I'll focus my comments on the powers of my office, and I think Section 10, and also in Section 22 in relation to strike down and incompatibility declaratives, which allows for intervention in those cases. And I think that this is a really important power. Already, since I took office in 2017, I've restructured and built expertise within the office around this within existing rules. And so we've made a number of interventions at the Court of Session and indeed recently at the Supreme Court, just relying on the rules of court. And so having this power actually set out specifically on the Act, on the bill, is really useful. And I think that's a really important point in terms of what we can do to ensure that the court is assisted in taking cases. There's also an additional power in order to take cases in my own name as Commissioner, and I think that's a really important new addition. And this would allow us to take forward strategic issues. And Janice Scott, again last week, I'd referred to the example she gave of Northern Ireland on physical punishment, where they weren't allowed to take a case because they didn't have power. And again, I very much welcomed the work that the committee did to secure protection from assault for the purpose of physical punishment in Scotland, which has recently come into force. That's very much the type of thing that I would look to use strategically. And I suppose it's important when we look at this to put it into context, is that my office doesn't have a complaints handling power. Rather, we've got the great work that Rosemary and her team does, SPSO and judicial systems, rather than we don't have a children's ombuds model. So my job isn't to deal with complaints, but rather to look at how we can use strategic litigation. And this links back with the previous points that were made. This isn't a substitute for child-friendly complaint system or child-friendly justice. There's still a lot more need for support and legal aid and mechanisms for individual remedy, and the important role that civil society plays. And again, I'd point to the great examples from Clan Child Law and Just Right Scotland, where they've been really leading the way in showing how strategic litigation can work. But a really important point, I suppose, is that litigation is a really poor way to address rights violations, and so it should really be a last resort. And so the focus of this bill on ensuring that rights are respected, protected and fulfilled and preventing breaches is really important because it means that we should be able to prevent as much litigation as possible. And that's been the experience in other countries, is that litigation is only necessary when other things aren't working and where there's been a failure. And certainly what we would look to see through the broader provisions within the bill to make sure that breaches aren't happening, a preventative approach through all of the things we've talked about and the measures of implementation to actually avoid the need for taking cases. But it's absolutely essential that the power is there, and so the power to intervene before the court, or the power to take cases in our own right where there's a strategic need to do so. So very warmly welcome these powers, and again in relation to Section 7 would refer to the evidence that's already been put in terms of that significant interest test.
Okay, thanks for that. Kavita, would you want to come in on this as well?
Yeah, I suppose the short answer I have to your question is that yes, we are happy with that approach, and it is really important to consider who can raise proceedings under the bill, particularly because of all of those barriers that we talked about earlier that children and young people have in raising challenges. So it is critical that the Children's Commissioner has that power to raise proceedings under the Act, and they've got a really central role, both as the Commissioner said, in promoting the rights, but also in enforcing the rights in the bill, and we fully support that dual functionality. I think really what we want to see is quite an inclusive and broad rules of standing that allow children and their representatives or advocates and those who seek to advance children's rights to be able to raise actions as appropriate, which would include civil society organisations, multi-party litigation, etc. And as you heard last week, it's critical that victim test, which is required under the Human Rights Act, which is quite restrictive in practice, hasn't been carried into this legislation, and that's really welcome. And instead, we've got the usual rules for standing for judicial review actions, the sufficient interest test. And I think witnesses spoke last week to that evolving understanding of that standing interest test post the AXA case, where it was explained and it was expanded, the rules of standing, to include those who were acting with genuine concern for the public interest, even where they had the absence of a private right or interest of their own. And in short, that's really welcome, and it does allow for that more expansive approach to standing, which allows for children and young people and those representing their interests to raise actions in the courts in a way that protects both individual rights but also that broader public interest.
Okay, thanks for that. I see that Rosemary's not wanting to come in here, but feels that it's already covered. Dragon, are you wanting to come in on this question?
Thank you. UNICEF is very happy with this section of the bill. We are delighted to see that the Children's Commissioner's powers have been strengthened. I would just like here to point out that in 2016, the UN Committee on the Rights of the Child put forward a recommendation to the Scottish Government that the Commissioner's powers should be strengthened and also include the power to deal with individual complaints, and importantly, that all resources should be enabled and made available to the Commissioner, financial and human resources, to be able to perform these functions. So we very much hope that such an enhanced important role for the Commissioner in the bill will be fully supported by availability of all resources needed. Thank you.
Thank you. Ellen, have you got anything to contribute in this question?
Just very briefly, that we don't have these kind of powers in Norway, and what we see that it's quite coincidental that which cases are brought to court. And I think that to give powers to child rights advocates to bring cases to court, it will help to get the right cases to a court decision, strong cases, relevant cases for children's rights, so that they will get a court decision. And I think that will be very good.
Thank you, Alan. Fulton, if you could you possibly roll your final two questions together, just so that we've still got Alison to come in and only 15 minutes left in this panel. Thank you.
Yeah, well, convener, I did have a question on the still staying on court proceedings on time limits. I probably should have rolled in, but if you don't mind, I could maybe ask for a brief answer for some of the panel from that. Would that be okay?
Yes, by all means. I'm just trying to conflate your other two.
And then I'll do so for my questions. So in terms of time limits for bringing court proceedings, we've received submissions offering mixed views on whether it is correct to exclude the period when a young person is under 18 when calculating the time limits for raising court proceedings under Section 7. I'm wondering if any of the panel would like to comment on this and the overall approach to time limits, just even to have that on the record. Perhaps Bruce first.
I strongly support the approach that's been taken. When children's rights are abused, the time where they're still a child should not be counted, and I think the bill does well in doing that. The argument that's being made that this may place challenges on public authorities in order to address those matters, I think needs to be set within the context of the balance of power here. And what we know is that justice is very hard to come by from children and young people, and often they may not even know that a rights breach has happened until they're older. And so I think the approach that's being taken here is absolutely the right one. If there are challenges to overcome, then they should be done on the favouring children's rights to an effective remedy. And so I'm very pleased with this section and excluding any time when a child is still a child before that clock starts ticking in terms of time limits.
Okay, Kavita, this might be something you want to have a quick say on.
Really just to say that we fully agree with the views expressed by the Children's Commissioner there, and we really welcome that children are excluded from the requirement that cases must be raised within 1 year, and instead the clock commencing when they turn 18. And as we've discussed already, there are so many hurdles to a child or young person. In the first instance, recognising any potential violation that's occurred and then accessing the necessary supports and resources to bring any sort of challenge. So this is an entirely sensible approach that we would support.
Okay. Back to you then, Fulton. I think we've probably got some decent views on the record there, and just keen to get all the questions in.
I appreciate that, convener. And if I could ask the panel to bear with me here, there's 3 questions in it, and under normal circumstances, I'd have probably preferred to ask 3 separate questions, or at least 2. So in terms of the children's rights scheme, you'll know that the bill requires Scottish ministers to publish a children's rights scheme to report on compliance with the UNCRC requirements and to be reviewed and reported on annually. Can I ask the panel what your view on this provision is, and if the suggestion that we've had some suggestions that the language in the bill could be stronger, how do you feel about that? And my second question related to that would be, do you think the scheme should have a clear commencement date? We had pretty strong views on this last week as well. And the final part of my question is around children's rights and wellbeing impact assessments. I'd like to hear the panel's views on the legal duty on Scottish ministers to prepare these assessments for legislation and for decisions of a strategic nature, and to what extent should ministers have this discretion. I would appreciate your views on that. I'm sorry, that's a quick whirlwind there. Hopefully you're able to answer in each of those as you see fit.
Okay, thanks. Go Bruce, in order again then. Bruce, and just to say that Rosemary Agnew has posted in the chat that she supports the views expressed in the last question as well. So Bruce.
Those are 3 really big questions, and I'm very aware of time, and so again, I think I'd take the opportunity to write further. But starting with commencement, I think this is really important that we have commencement on the face of the bill. Tomorrow is the 31st anniversary of the convention. Children have been waiting a very long time for this. Public authorities have already had the obligations via state responsibility for a long time, and certainly specific duties since the 2014 Act. And a note in COSLA's evidence that they already pointed to the great work and knowledge that already exists in terms of children's rights and the human rights agenda. So there is no need to delay. And so I would favour immediate commencement put on the face of the bill, because there is really no justification for delaying. I'm pleased we've got a really strong bill, and I think we can improve it through the parliamentary process, but it needs to be, in effect, rights need to be real. This is something that the first Children's Commissioner, Kathleen Marshall, raised right back when the office was created in 2003 and 2004. Those children are now adults. And I think when we look back to the 2017 Scottish Youth Parliament campaign, it was called Right Here, Right Now for a reason, and children have waited long enough. And even, I think, 6 months may not seem like a very long time to adults, but think about it from the point of view of children. And I received just this week an amazing video, which is I think being sent to the committee from Holy Cross Primary. And one of the strong things that they were talking about is how excited they are about this bill, but it needs to be in force. And one of my own young advisors said that if the bill's passed and not commenced immediately, this will confuse children and young people as to whether their protections actually exist or not. And so a very, very strong view from me that commencement needs to be as soon as possible. I would favour immediate commencement, but there should be no further delay. Children have waited long enough. On the human rights, on the children's rights scheme obligation, I think it can be strengthened. Again, there's been some good examples given in this session and the last session in terms of some of the things that we would need to see in it, particularly around things like child-friendly justice. But again, we've commented extensively on that already. In relation to children's rights impact assessments, that was actually the theme of the European Network of Ombudsmen for Children's thematic work for the last year, and it culminated in a 3-day conference we've just hosted via Zoom, unfortunately not in Edinburgh, on children's rights impact assessments. And so we've got a very high level of knowledge of the situation across the Council of Europe area, and we can make available the position statement of ENOC and the common framework of reference that was developed, which we'll be promoting with government and public bodies. Impact assessments are an absolutely vital tool in ensuring that decisions are made effectively. But the experience across Europe, I think is worth noting in the very brief time we have, is incredibly variable. And one of the concerns from some of those countries that have made impact assessment obligation on all levels of decision making, there is a risk that you can stray into kind of tokenism and bureaucracy. And so the real key to effective impact assessments is their quality, and so the kind of training and support that needs in place. Having an enforceable legal obligation on you, I think, puts a very strong emphasis on ensuring that you're making decisions effectively, and children's rights impact assessments are a very powerful way of doing that. And so we strongly support them. It's really important there's the legal obligation on Scottish ministers, and I think COVID has shown us where some really good examples of where if there's a lack of impact assessments, poor decisions can be made. So we strongly support them and the way in which they're drafted into the bill. And again, we can expand on this at length in writing to the committee.
Thank you, Bruce. Kavita.
Thank you. The requirement for the scheme and to report on both steps taken and plans, I think, just to emphasise, it's a really important means of ensuring children's rights are advanced in practice, and we really welcome that as a innovation from the Human Rights Act model. 2 issues very briefly in relation to the scheme. Firstly, section 11.3 sets out what may be included in the scheme, and we do think that amending that may to a must would be a most welcome amendment in securing that those issues really are looked at in practice. And then secondly, and I think I've talked about this before, we would recommend that the list of what's included in the scheme is potentially expanded. So it could, as I say, usefully include, for example, arrangements of Scottish ministers to improve children and young people's access to justice through child-friendly complaints mechanisms, advocacy and representation. Additionally to that, we think the scheme should also go beyond. It talks about at the moment awareness raising and promotion of children's rights in the scheme, and we think that could also make reference to advancing human rights, children's rights, education and training as another really important element there. So that's just 2 brief comments in relation to the scheme. In relation to commencement, just to say that we would also say that we really think it's important that this bill has a specified commencement date as soon as practicable, rather than left to the discretion of ministers. We do recognise that duty bearers will look for a preparation period, but the UNCRC has been part of our international obligations for a long time now, and public authorities have had a duty placed on them under the 2014 Act, which has put them in a good place to prepare for this bill. And really the experience of COVID-19 has arguably really accelerated the need and the case for advancing these obligations in law sooner rather than later, and to systematically build that into decision making. That case has never been made clearer than the experience over past months.
Thank you very much, Kavita. And Rosemary Agnew.
Thank you. I won't add anything to the discussion about commencement and what have you, but there is something about impact assessments I'd like to add an additional point on, and it's to do with implementation. They are a great way of ensuring you get that build-in in policy making, decision making from the start. But as a public body already myself, I already do a data protection impact analysis. I do equalities impact analyses. And I think we need to be very careful, picking up on Bruce's point, that we don't introduce another silo of an impact analysis that ends up considering things divorced and separate to each other. We need to ensure that it's not too bureaucratic, but there is support and guidance about how to do it effectively, and that there are resources available for public bodies to do this, so that we do a meaningful rather than a tick list type approach. Thank you.
Thank you very much. And Dragan?
Thank you. Very briefly on these three questions. Regarding commencement, we are very happy with the commitment by the Scottish Government that the Act will enter into force as soon as possible. We, as a UNICEF, an intergovernmental organisation, do not tell governments or parliaments what they should specifically do. Every country take their own path according to their tradition and system. I would just like to mention here that, for instance, in Iceland, the Incorporation Act went into force immediately. However, in Sweden, there was a delayed entry into force of 1.5 years to allow duty bearers, especially judiciary and local authorities, to prepare for implementation. So I hope that your Parliament will find a consensus with all stakeholders. On the child rights scheme, we think that it can be strengthened in two ways. Number one, the current formulation that the Scottish ministers may include arrangements should be strengthened, and perhaps with the word should or shall. And then also the list of things to be of issues to be included, the arrangements to be added to the child rights scheme, we think can be and should be expanded. On the issue of child rights impact assessment, we are delighted to see a mandatory child rights impact assessment on the Scottish Government. Again, this is one point where the incorporation bill goes further than anywhere else in the world. One area there for improvement is when it comes to decisions of strategic nature. We think that is a little bit vague and broad, open to really a subjective discretionary assessment. We would recommend, and apologies for that, to use the formulation in the child rights impact assessment process and template used by the European Commission that was developed by UNICEF. When it comes,
I'm very sorry just to hurry you up a bit, because we have more questions to come in and only 5 minutes or so left for the whole panel. So if you could draw your remarks to a close, that would be very helpful.
So my suggestion is that the child rights impact assessment must be done for every decision which has direct or indirect impact on children. Thank you.
And I apologise for cutting you off there. And finally, Ellen.
I think I can leave my comments on this one. I think that they have been answered.
And thank you to Fulton McGregor. And I bring Alison Harris, who will round off the session. Questions.
Morning panel. I'll be quite quick if you don't mind. I would like to discuss about the incompatible legislation. So Part 4 of the bill sets out the significant powers in respect of incompatible legislation. Do you have any comment you would like to make on Part 4? And we're particularly interested on your views on the approach of the courts and the declarative powers and the reporting duty set out in section 23. I'll go to the panel for that question, please.
Yes, thank you. We think this is useful in terms of particularly the strike down declarators and also the interpretation section 19, which allows courts to read down incompatible parts of legislation, which I think is very useful. And also the incompatibility declarators. We understand the reasoning of government in terms of the powers available to the devolved parliament and the restrictions on that. Although it's obviously a much stronger power to strike down. The ministerial reporting is really important because, again, what we've seen, particularly from experience in international fora such as the European Court on Human Rights, is that execution of judgments and implementation can actually be very slow. And so this reporting duty, I think, is very, very useful. And again, I would refer to the section 22, which requires a notification of my office when such proceedings are taking place, and provides for the opportunity then to intervene in those cases, which I think is a really important additional power that we have as well. So we strongly support what's taken here, understanding that the argument is this is as far as we can go within devolved powers. Obviously, we would like to see strike down powers in relation to both past and future legislation.
Thank you.
Kavita?
So the approach taken in the bill to this strike down declarator for incompatible provisions predating the Act and incompatibility declarator for provisions that are incompatible post-dating the Act is most interesting. In a Human Rights Act context, a declaration of incompatibility has been found not to be an effective remedy where the incompatible provisions effectively remained on the statute book. And no action has been taken to secure its compatibility. Now, we understand the reasons for the incompatibility declarator to ensure that we remain within competence of the Parliament. As I say, in an ECHR context, to meet the threshold of an effective remedy, there needs to be a long-standing and established practice of giving effect to the court's declaration of incompatibility. So it needs to be acted on effectively to remedy the incompatible legislation. But what is really different and interesting about this bill is that it is supported by those further measures to secure compliance in practice through the reporting duty, etc., to ensure that an effective remedy is provided for through the impact assessment, the statements of compatibility, the requirement of ministers to report, and the remedial power. So viewed as a whole, in conjunction with those other measures, we think that does go some way to provide for an effective remedy under the legislation, subject to those comments I made earlier around the need to evolve remedies in our courts and look at more structural remedies to deal with those issues of a systemic nature affecting multiple people. So that's all I've got to say on that. Thank you.
Thank you very much. And Rosemary Agnew?
Comment on reporting. I think it is absolutely critical that there is reporting, but I think we need to be very clear about what we expect to see in that reporting mechanism and focus on not just what we've done, but also what we've learned.
Thank you.
Finish there.
Thank you. And Dragan?
We are very happy with this section of the bill, and we think that the measures envisaged will ensure that future legislation is in line with the Convention. One thing I would like to mention that it is vitally important that the review of existing legislation starts as soon as possible in the future. Indeed, Scotland can expect the UN Committee on the Rights of the Child in February next year to ask the Scottish Government of when it plans to start conducting a review of legislation following the incorporation. This is something that has happened in Norway and Sweden, and as a result of that, a number of existing legislation there have been amended to make sure that they better are in line with the Convention on the Rights of the Child. Thank you.
Thank you. And finally, Ellen.
Perfectly, so I have no further comments.
Thank you very much. Alison, do you have further questions?
Yes, I would like to ask about resources and costs. Do you have any comment to make on the potential impact on resources and the cost of the bill to your organisation, to public authorities generally, and to the third sector?
Okay, Bruce? Yeah, sorry. Bruce.
Yes, again, aware of time, convener. I think, as others have commented, the experience in other countries has been that there hasn't been a significant need for additional resources. I'd point to Article 4 of the Convention, which focuses on using available resources to the maximum extent possible, and also strongly refer the committee and endorse the work the Scottish Human Rights Commission has been doing on human rights-based budgeting. There's a lot of work on children's rights-based budgeting, which shows that actually taking a rights-based approach leads to better and more cost-effective decision-making in the long term. So while it is important that there is proper resourcing to make sure that awareness is raised, that's already a function, that's already an obligation of the state. We should be spending this money anyway, even if we didn't incorporate. And it's money very well spent. And so the obligation to make sure people are trained and understand and that children are educated on their rights, all of these pre-exist this legislation. And so the money that's spent on this is resource very, very well spent. And I think more focus on human rights-based budgeting and children's rights-based budgeting is very useful. Obviously, within the bill, there are additional powers for my office. We set that very much within our general duty to safeguard and promote the rights of children and young people. I could happily talk to you about how my organisation's funded a lot lower per capita than colleagues in Northern Ireland and Wales, but that's a discussion perhaps for another time. But our approach to the use of our powers under this legislation is very much the same as that we have taken so far, which is to use the strategic use. I would foresee that if there was consistent failure by public authorities, that the cost of using those litigation powers would increase over time. But my hope is that by using the mechanisms within the bill to actually deliver this change, it's actually very cost effective and actually saves money over the long run. If we're ending up spending money on litigation, something's going very wrong in the way in which the bill and the obligations that sit underneath it are being implemented.
Thank you, Bruce. If Dragan and Ellen are okay, I will just ask Kavita and Rosemary to come in this, because this is specifically about the resources of UK organisations implementing, or Scottish organisations implementing this. So can I have Kavita, the Human Rights Commission, in a nutshell, do you need more resources for this?
In a nutshell, as the bill stands, we do not need more resources, particularly to implement this. The Children's Commissioner is resourced through the Parliament to do that. I would just say that I endorse the Children's Commissioner's answer there, because in terms of public bodies and resourcing, I think one thing that's really important to understand from a human rights law perspective is around the sort of underlying obligations that they're being asked to fulfil here. And to some degree, they can be assured that this is a framework which to a large degree fits with their existing priority setting, budgeting and policy making processes. And it's about building children's rights and considerations into those processes. Sorry, I'm aware I'm probably out of time.
Rosemary, do you have anything to add?
A general comment, I don't think anything ever comes completely for free. And I do think we should be encouraging reuse and using current resources well, and encouraging creative solutions. For my own organisation, where I think the greatest impact in the early days is likely to be, is in giving support and guidance and developing complaint processes that public bodies can deliver that don't hopefully end up with a requirement to come to an ombudsman or a court.
Thank you. Alison, do you have anything further to ask? I mean, we really have to end this here, unfortunately, but is there anything?
It was a very brief question on going further with the bill, but I think I'm happy, convener, just to leave it as is.
If that's okay, we'll draw this session to a close. Can I have thank the panel for their comments. It's been extremely helpful. Particular thanks to our international visitors. I'm going to suspend this very briefly, just so we can change panels, but would reconvene in 3 minutes, if that's possible, just as soon as everyone's in place. Okay, are we ready to go? Just conscious of time, can try and this up by 35 past. Okay, and welcome back. Okay, so welcome back to the meeting, and I'd like to start by welcoming the witnesses of our second panel. Eddie Folan, who's the Chief Officer for Children and Young People at COSLA, ACC's Gary Ritchie, Partnership Prevention and Community Wellbeing at Police Scotland, Alistair Hogg, who's Head of Practice and Policy at the Scottish Children's Reporters Administration, and Mike Burns, who's Assistant Chief Officer for Children's Service and Chief Social Work Officer at Glasgow City Council Health and Social Care Partnership. Welcome to you all. I'd like to thank you for being here this morning. Unfortunately, our time is limited. We're hoping to wrap up by about 25 to 12. And so I would ask both questioners and panelists to be succinct in their questions and answers. Please just give a brief pause so that the microphone and camera can pick you up when you're asked a question. I have two questions, but I'm quite happy to roll them into one. It's a general opening question to our panelists. Firstly, to say there is strong support for incorporation of the UNCRC into Scots law. What do you think of the general approach of the Scottish Government in this bill? And particularly, what guidance do you think that public authorities will require in order to ensure that they meet the duties set out in the bill? And if I go to Eddie Folan first.
Thank you, convener. I suppose the first thing to say, just in general terms, is we very much welcome the bill. And we welcome the principles in the bill as well. We've discussed it extensively with our Children and Young People Board, which is made up of the 32 conveners of education and children's services in Scotland and across local authorities, and there's full agreement and support for the bill there. We want to make sure that children's rights are realised across public services. We've also had extensive discussions with our local authority partners, including chief executives through SOLAS, education through ADES, Social Work Scotland and the Scottish Councils Equalities Network. And I think in general terms, you know, we've, as I said, we very much support the principles of the bill and the approach that's been taken. There are challenges, and I think we can go into some of those. You know, the local government workforce is some 250,000 people strong, so there's a challenge there. But that is one that we're certainly up for taking on. And in terms of guidance, you know, I think we were kind of clear in our submission that we need guidance that is, you know, that's carried out in partnership, that's done in partnership with us, that builds on best practice, that looks at what's there and what works at the moment. We also need to make sure that that guidance is fully consulted on, and that it's fully informed by the views of children and young people. And I suppose it would also be really useful, I think, to make sure that the guidance makes clear where the convention sits in relation to the wider kind of legislative framework in Scotland. I think that, there's a lot going on at the moment. We've got age of criminal responsibility, we've got the redress bill as well, and UNCRC. So I think it's a complex landscape, so the guidance needs to be clear and it needs to be strong. I think also, that there's a case, certainly in consultation with our partners that and through SOLA, there's a case for the guidance to be statutory if that needs to happen. And I think there's a view in local government that would be helpful. I hope that's safe enough.
It is. Thank you. I'm very grateful. Now I'd like to bring in ACC Richie from Police Scotland.
Thank you. Good morning, and good morning to everyone on the call. Thanks very much for the opportunity, first of all. And yes, in answer to your first question, Police Scotland are of course fully supportive of the principles behind the bill. And we're already, as you know, we have our Children and Young People Plan in Police Scotland. In respect to the bill specifically, we've set up a short life working group in order to provide direction and leadership throughout the organisation, even at this early stage. We already have other working groups in place for the similar attendant legislation, about the Equal Protection Act, and as Mr. Foley mentioned there, the Age of Criminal Responsibility Act as well. So we are fully committed and fully positioned and ready to progress as we're required to. In respect of asks, again, very similar, I think, to what Mr. Foley said. The detailed guidance is going to be really important as we progress through this, and in respect of expectation. That consistent communications plan, and we've seen recently in our engagement with government around coronavirus legislation and other legislative instruments, just the value of very strong collaboration as legislation is developed has helped that joint understanding of implications and obstacles and the practicalities, which I think is important for all sides to understand. So that's really important that dialogue continues. And should there be any particular governance structures in place, of course, that Police Scotland remain fully represented on them. Thank you.
Thank you very much indeed, ACC Richie. And I'd now like to bring in Alistair Hogg.
Thank you, Convener, and good morning, everybody. And thanks also for inviting us to give evidence today. I represent Scottish Children's Reporter Administration, and we clearly very much welcome and support the bill. As an organisation, we are, of course, very focused on children's rights. That is core to our business, and as is the protection of children and upholding their rights. We've always considered that we have always had a duty to comply with UNCRC and would always strive to do so. But what the bill does in incorporating into law the UNCRC is to raise the prominence and really to offer the real opportunity to bring about cultural change that is required in order to promote and enshrine children's rights in every part of Scottish life. So we're very supportive of the bill and what it's trying to achieve. Key to that cultural change driving forward is the opportunity of enforcement rights that exists within the bill, not necessarily with a view to thinking that we would hope that those enforcement rights would have to be used all that often, but having those enforcement rights there are an absolute key to driving the change and motivating the change. So very supportive of the bill. In terms of what asks, again, as the first two contributors have indicated, any guidance documents would be very welcome. Although observing children's rights is core to our business, there is always a lot to learn and to understand. And also, one of the asks that we would have is that one of our duties will be, and we've already started to do this, is to consider all the work that we currently are doing, all of our policies, our procedures, our processes, to make sure that they are compliant with UNCRC, and some provision of a toolkit, some kind of audit framework would be very helpful for us in order to undertake that work to a full extent. Thank you.
Thank you very much, Mr. Hogg. And finally, of our panellists, I would like to bring in Mike Burns.
Thank you, Chair. Good morning to yourself and to the panel. I would certainly echo the points that have been very eloquently made. I suppose I would also say that it is, in a sense, building on the bedrock of the Children's Scotland Act 1995, which did actually encapsulate quite a number of the articles, and I do think also the issue in relation to getting it right for every child, which has been a policy direction that we've been implementing in Scotland since 2006. So I think it is important for us as a society to continue to promote, protect and develop children's rights. So I think to welcome that, and I suppose echo the point that how that is then stretched across the whole of the public sector and statutory organisations, I think is really important. I think the issue in relation to the guidance is actually something that is of significance, because I do think there is a need for consideration about alignment and coordination and the cohesion. I think the bill very helpfully at page 8 outlines all the legislation that continues to impact in children's services, and I do think there is a need for significant coordination in relation to the guidance. I don't think it's sufficient just for the guidance to come out separately. It's got to be cohesive.
Thank you very much. And before I bring in Mary Fee, I have a very specific question to ACC, Rich. We know that the Age of Criminal Responsibility Act, which you referred to in your answer, has still not been implemented, and we're told by the Scottish Government that is in part down to the needs for training and understanding of the police force. I just wonder if you could explain where the blockage is in that, and whether there might be a similar blockage with implementation of the incorporation of the UNCRC.
I think it's because of the scope of the challenge of implementation and understanding what that means across the range of legislation that we have to consider, I think, on a daily basis. I mean, when police officers are actually dealing with children as part of their duties, I mean, there could be 5 or 6 different pieces of legislation that they need to consider there, which variously at the moment define the age of a child between 16 and 18. So the same thing happens, I think, whether you're dealing with a child as a victim or a potential offender. That's one element of it. I think the second element is to do with it's about the practical implementation of it, because you've got numerous systems across Police Scotland, as you'll understand, many of which are set up and have, I'm not a technical person, but default settings which trigger other processes, all set up at the moment in relation to a child being under the age of 16. If that's raised to 18, then all of these need to be adjusted, as do our policies and our processes and our operational practices. So it's a real significant change. I would hesitate to call it a blockage. As I say, we're fully committed to actually ensuring that legislation is implemented in the manner that's intended.
Sorry to interrupt you there, Gary, but this is just about increasing the age of criminal responsibility from 8 to 12, not around the confusion as to whether somebody's an adult at 16 or 18. Is there any sort of line of sight as to when that's actually going to come in?
It's another functional area that's working under that at the moment, Chair, and I'm sorry I don't actually.
It's absolutely fine. I'm keeping you on that, actually, if that's okay. If we can speak to other colleagues in Police Scotland on that specific thing. Sorry to buttonhole you on that. So if I can bring in Mary Fee with her question.
Thank you, Convener, and good morning, panel. I have 2 questions for the panel this morning. And the first is on Section 4 of the bill, on the interpretation of the UNCRC requirements. Does the panel think that that should be expanded to take account of general comments and concluding observations or any other opinion or international human rights treaties? And are there any unintended consequences if the bill were to be amended in this way? Thank you.
Oh, sorry. Sorry. I'm used to doing this. Absolutely. So Eddie Fullen, if you want to come to that first.
Thanks very much and good morning, Ms. Fee. Yeah, I mean it's not something that we've had a strong view on. If I'm going to be perfectly honest with you on that one, and I might have to ask other colleagues, but you know, I think anything that can strengthen the bill would be welcome by local government. I mean, we've been really focused on the kind of higher level, the resources issue, making sure that the guidance is strong, that kind of thing. So I don't want to, mislead you by giving you a kind of false steer on what we think, but certainly, if it strengthens the bill and it's in the kind of best interests of children and young people, it's something I'm sure that local government would be supportive of. But I know that my colleague Mike Burns may have another view from a practical perspective.
Thank you.
Okay, and my apologies again. I've had some technical issues with Wi-Fi dropout, so forgive me if this seems rusty. So ACC Richie, if you could answer Mary's question, please.
Very similar to what Mr. Fullen said. It's I don't know that it's really for us to comment in that. I don't need to say. I think you get the best legislation from the widest consultation.
Okay, thank you.
Alistair Hogg.
Thank you. Really just would say that I watched the earlier session today where you got quite a rich source of information in relation to that, and obviously there was some further information from the previous session last week. I think from my perspective, I would see that the courts or tribunals having access to any kind of guidance or information that comes from those sources would be helpful. But I think I would align with comments that I think were made last week by Janice Scott when she was saying that all of that would enrich the consideration of the issue at hand, but would not be binding upon the court or tribunal. I think that's quite an important point, because that if they were to be binding, then that would greatly increase the complexity and the influence from other sources. But I think that to be able to consider them would be helpful.
Okay, thank you.
Thanks, Alison. Burns.
Again, I think it's a very legalistic and technical issue. And again, like Mr. Fallon, much detail to it. I think interesting. I mean, the only thing I could kind of comment on in relation to the debate is about the whole promotion of the values of it, and I think it's that values that I think is then got to challenge professionals that are working in that arena, so that it's not just the law, but about the spirit of the law being enacted in everyday interactions that we have with children. So I think from that perspective, it's just about the whole promotion of that. Sorry.
Okay, thank you.
Thank you.
Mary.
Thank you. Thank you, Convener. My second question is on definition of public authorities. And if panel listened to the earlier session, they'll know there was a fairly lengthy discussion around what the definition of a public authority should be. So I'd be keen to hear this panel's views on whether you think that definition needs to be changed to include some of the private sector bodies that carry out public functions. So if I could start with Eddie Follen, please.
Thanks very much. Certainly, again, in kind of consultation with our members, we were content really with the definition of public bodies as they stand. However, there are clearly issues around those bodies who deliver public functions. I think that probably, and I never listened. I wasn't able to listen to the full panel earlier, but I know that there are a lot of complexities around how that would be done, how it would be carried out. So and also an issue that may be addressed in guidance. I know the legal, the kind of legal duties on public bodies as they stand. But certainly from our point of view, from a COSLA point of view, we're comfortable with the legislation as it stands in terms of public bodies. But I think we would also be kind of open to, open to kind of discussion on how that would be extended, if that helps.
Okay, that's helpful. Thank you. That's helpful. Thank you. Yep.
DC Ritchie.
I'm in danger of just saying yes. I think for every answer. I mean, the purpose of the bill obviously is to affect cultural change, and I'm probably straying into a personal view here. I think when we're looking at accountability, then it's important that if we're going to see that cultural change, that's as wide as possible. Whether that's achieved by actually wide definition of public authorities is not really for me to say, but as I say, I'm straying into a personal view there.
Okay.
No.
Thank you. There's no obligation to answer any of these questions from panelists. So, Alistair Hogg, if you go next.
Thank you. Could I just first of all say, having seen the evidence from previous sessions, there was, which I think has been cleared up now, but just to absolutely make it clear, there was a question about whether children's hearings would be considered public authorities. Right, yeah. I think certainly I can speak on behalf of my own organisation that we have absolutely no doubt that we are public authority and would be covered by this bill, and I'm pretty confident in saying that our close partners, Children's Hearing Scotland, would have a similar view. So in terms of the kind of wider issue about definition of public authority, I think the area that was explored was in relation to private providers or privatisation of services, etc. And I think there was a very good submission, which I think was from Rosemary Agnew earlier, where she was, I think, suggesting that if you were carrying out a public function, then you should be covered by the expectations of observing the UNCRC. So that would be an approach that I would certainly support, that SCRA would certainly support.
Okay. Do you think, just before we move on to our next panel member, in relation to the answer that you have just given then, do you think it would be helpful if you are content with the definition that there should be almost a kind of an explanatory note just listing who a public authority would be? Would that be helpful to you?
It can sometimes be helpful because it can remove any doubt in relation to any areas of which there are doubt. I suppose there could be a disadvantage in that, is that an exhaustive list, and would you continually require to update and review that? But I could see that there could be potential advantages in increasing clarity in that regard.
Okay, yeah, that's helpful. Thank you. Thank you.
Thank you. In which case, can I bring in Mike Burns?
Yeah, so I think similar to Mr. Fallon, we would be content with where the law sits at the moment. I do think, similar to the points that have been raised about, personally, I think if it is about promoting this right, then we need to look at promoting it across society, across communities, and also with parents. And I think, therefore, as an evolution, because I think you would want to get the public bodies right first with where they're holding statutory duties, but I think allow, as it should do, the legislation to evolve into those other areas where we're then hopefully, by best practice, the points has been made earlier, influence and to meet and understand the philosophy around the promotion of the child's rights and the child's views. So I'd be content at this stage. Thank you.
Thank you.
Mary, do you
Sorry,
have any more?
No, no, thank you, convener. That's me finished my questions. Thank you.
Thank you. In which case, I'll bring in Fulton McGregor.
Thanks, convener. I'm just wondering, was Alison Harris not wanting to come in here to finish off this line of questioning?
Oh, my apologies. Alison, you're welcome to come in, and then I'll bring you back in at the end as well. So, Alison Harris.
Thank you, convener. I would like to ask about the time limits for bringing court proceedings. So would you like to comment on the time limit for bringing court proceedings, and will an extended timeline be an onerous burden in terms of record keeping as suggested by the Faculty of Advocates? To have your comments, please.
Yeah, Alison, and if I can go back to the panel and bring in Eddie Follen first.
Yeah, thanks for the question. Again, I'm in danger. I'm in danger of saying that that that's not an issue that we've considered in detail. But I think what I would do is I would go back to her position on support for the bill. So if the bill as it stands was something that local government and our partners in local government were really supportive of, but it's probably not. It's not an issue I would want to kind of comment on in any detail.
Okay, and ACC Ritchie.
Yeah, again, Chair, to be brief, again, it's not something that we would necessarily comment on.
Okay, in which case, Alistair Hogg.
Thank you. So I think there's possibly two elements to the question, but maybe I could just clarify that. I know that there was quite a bit of discussion in previous sessions around the timeline in relation to whether you calculate any of that timeline up to the age of 18 and whether for a child you should not count that timeline. I'm not sure if that's part of what you're asking, or is it just around the record keeping in relation to that?
No, it's part of it.
Yeah.
Oh, sorry, Alison.
So thank you. So I've obviously, as I said earlier, observed the previous sessions and some very interesting views put forward, and I think very clear view expressed earlier from the Children's Commissioner in relation to that, and absolutely agree with the sentiments in that regard. I would say, however, that I do understand the point that I think Janice Scott had made in an earlier session, which was simply explaining the practicality of that, which is that, yes, of course, it's the right thing to do not to constrain a child with those time limits, similar time limits to adults. That would be unfair to do so. However, the remedy that you may be seeking requires to be done quicker than that. So there's a practical impact from that. But I think that on balance, it's the right thing to do in relation to those timelines. It's an interesting question about maintaining of records. Within our own organisation, we have a retention policy which allows us or expects us to delete our records once the young person reaches the age of 18, unless there's an exceptional reason why we should hold on to those records. And actually, if there is an existing timeline which indicates up to a year after their 18th birthday, then that would have implications for us that we may require to hold records until they reach the age of 19 and potentially longer if there are proceedings that are ongoing in relation to that.
Thank you, Alistair. And Mike Burns, finally.
Yeah, I think I would concur with the earlier evidence that you heard about a very reflective and supportive approach in relation to the time limits and the time bar. I think that absolutely makes sense, particularly when you're dealing with children where there might be the need for redress, or there might be the need in relation to childhood trauma to, in a sense, take account of that. Again, I would go back to the issue about even, I think, the 1995 Act and legislation since has really kind of strengthened records. I think there may be a challenge in relation to the quality of record keeping. In actual fact, looking at how we enact children's rights IT systems across Scotland in relation to recording is one that requires considerable resource and probably within a small country like ours, a significant degree of consistency would be helpful rather than probably the variations that we've got at the moment. There are really probably well set in practices about records retention that we adhere to, and I think is about with holding records for adoption, fostering, looked after that are held for decades. And we do obviously even now have a considerable number of people coming back with redress. So I think it's something that we do need to promote as part of this, not only the record keeping, but again, the record keeping then becomes critical in relation to capturing the view of the child, the best interests of the child, and then the professional decisions that are taken in relation to. And again, I think it's a really helpful question, and I think raises the issue about resources. Thank you.
Thank you very much. Alison, I'll bring you back, but in terms of the sequencing we've agreed, and we'll come to Fulton McGregor.
Thanks, Convener. Got a couple of questions around Part 3 of the bill. And the first is in relation to asking the panel what their view is on the provisions for Scottish ministers to prepare a children's rights scheme, and maybe a comment on some of the suggestions that we've had that the language in the bill could be stronger. So I would want to hear any thoughts on that, and is there anything you think should be added to the contents of the scheme? And also in this area, I wonder if the panel would be able to comment, as I asked the previous panel as well, about the scheme having a clear commencement date. Is this something that you think we should have? Thanks.
Thank you very much. So firstly to Eddie Follen then.
Thank you, Mr. McGregor. I did catch this bit in the previous panel, and I think the duty to protect on the scheme is welcome. I think anything that we can do to strengthen that is welcome as well. Certainly, our view from local government is that it's necessary. We know that it will be something that would be valued by children and young people. I think on the commencement date, would probably differ a bit from the Children's Commissioner. I think we need to keep the focus. We certainly welcome the 3-year implementation period, but on commencement, we need to be thinking of how, when is the right time to do that. As I said earlier, we've got a workforce of some 250,000 people in local government, and then you've got the wider public sector workforce beyond that. And what we need to be focused on is building capacity through training, making sure that everybody's aware of the legislation and their responsibilities within the legislation. And I think, I suppose we've had long discussions about this, and there's a real awareness of children's rights and children's services and in education. And in those services, it's something that's well embedded through GIRFEC and has been for many years. And there's a lot of good practice across local authorities. And there's, but there's maybe less of an awareness of that in other areas of the workforce. I think it would be fair to say that. I think we recognise that. But there's some really good practice. We know, for instance, in North Ayrshire, they've done some amazing work, really, and embedding children's rights across the workforce. But I think in a kind of long roundabout way, what I'm trying to say is, we need to just be cautious about commencement and bringing that in right away. I think, we need to keep focused on implementation and making sure we get it right, rather than kind of rushing to a commencement date. I absolutely get what Bruce Adam was saying about, we need to do this now, but we have got challenges. There's no doubt about that. We've got challenges in making sure that the workforce is fully aware of what they have to do. So I would be cautious about commencement right away, but let's focus on implementation and getting that right.
Before I bring in ACC Richie, I'd just like to push back on that answer, Eddie. It occurs to me, well, we heard in the last panel, in fact, that local authorities and public bodies have had a requirement, a legal duty, to have awareness of the children's or the UNCRC, and I just want to know why, given that they've had that duty for 6 years, this feels like base camp in terms of your answer there, in terms of getting everyone ready to understand what that means. Surely there is an awareness by the fact of that duty permeating through every local authority and public body in this country already.
Yeah, no, I mean, that's a fair point, convener. I think, the feedback that we've got is certainly that there is an awareness, but I think we can always do more. I think that's the point. And if we were to commence right away, there may well, because what we don't want to do is whilst we've got a system of remedy in the bill, we don't want that to be, kind of dragged in right away. We don't want to be in kind of adversarial situations right away, because we want to make sure that everybody knows what their responsibilities are. And I think as well, we're obviously living in very kind of challenging times, and public bodies have been under great, a fair amount of pressure in terms of local authorities in responding to COVID-19 and the pandemic. So it is a challenging time for local government. There's no doubt about that. It's a challenging time for everybody. It's a challenging time for children, young people, and families as well. So I think that our discussions with local government partners have been about, let's make sure that we do get this in and we get it right, but let's not rush right away to a commencement date as soon as the bill is passed. Let's make sure that we get it right. But that is in no way to say that we shouldn't be looking to commence it as soon as possible.
Okay, thank you for that. I mean, obviously commencement isn't full implementation. Commencement starts the implementation process, which we've already done the last 3 years. Yeah. Okay, I'll move on to bring in ACC Ritchie to answer Fulcrum's question.
Thank you, Chair. And again, a similar response. Just going back to what I said right at the start, I think it's important to have that clear guidance and demonstration of what's going to be required, and I think the commitment from government through the children's scheme will be helpful in terms of demonstration and building our own leadership mechanisms for what we have to do internally. It gives us a good overlap, lock-in, or however you want to describe it. So we're fully supportive of that. And again, I do take the comments that Eddie made in a very constructive way there about the timescales. It's important that we know what the timescales are and what's expected at each stage, so that we can build and prepare our processes as well. So whether that's 3 years to commencement and then another period of implementation, or whether it's 3 years to implementation, it's more important that we know what the expectations are and what our role will play in response to that, and when, so that we can plan appropriately. And again, I know it wasn't addressed to me directly, but you're pushed back there on the time that public services have known about this. I think it's fair to say, there's been an awareness, but it's that practical detail that I think we'll gain a better understanding of in the months ahead. That's really, really important to understand how it's going to impact on not just our officers and communities, but in the resultant demand on services as well. So that's what's important to understand.
Okay, thank you. And Alison Hogg.
First part of the question was in relation to the Children's Rights Scheme and whether there was any need to consider whether to strengthen that. And again, previous contributors have suggested that there are some areas where it could be strengthened. I think the Children's Rights Scheme itself is an absolute key to the success of the implementation of this bill and the success of what it's trying to achieve. So it's important that this is something that's really strengthened and is as strong as it can be. As regards to how you would strengthen that, there's been some good suggestions already, and in relation to what might be added to that scheme, I think that what's already contained within the bill does cover quite a lot and could be stretched to cover more. But I think that we've heard that perhaps one of the areas that it could be strengthened is in relation to enabling children and young people to have access to relevant support, and in particular access to services like advocacy or to legal aid to obtain legal representation. So that those might be areas that could be considered by the committee. But the Children's Rights Scheme itself is, as I say, absolute key driver here in terms of the success of this. As regards commencement, I'm probably somewhere in between. I completely agree with what the Children's Commissioner said earlier, that children and young people, having seen this bill coming forward and welcoming it, would expect that once it's passed, it should be started. But I also can see that for many public services, they would require a bit of time. I totally take the point that you've made, Convener, in relation to, should we not already be ready for this? To a large extent, yes, that is correct. And as I said earlier in my submission, we've always considered, my own organisation have always considered ourselves to be under a duty to comply with UNCRC. But where our thinking is that we would not wish to be complacent in thinking that we are fully compliant or that we couldn't comply even further with UNCRC. And we would like to conduct a proper audit of all of our processes and functions and policies to ensure that we're there. I think there is also a good point that was made, I think, by Eddie earlier, which is that in a normal time, if you could ever think back to what normal times were like, that it would be perhaps more straightforward to consider placing quite a tight timescale on commencement. But with recovery plans, we're still in the middle of the pandemic and trying very hard to come out of it and to recover from it. Speaking for the wide range of public services which will have to comply with the duties here, there maybe needs to be some cognizance of that. But I think that would be in favour of a commencement date being stipulated, because that will be a driver towards the implementation. And without one, it has the unintended danger of drift. And I think, Convener, you mentioned another example of where there has been a level of drift. And I think this is such an important bill that to allow that drift would not be a good message to children and young people.
Thank you, Alistair. And finally,
I think the issue. Yeah, thank you, Chair. Sorry. I think the issue around the Children's Rights Scheme and language, I suppose one of the things that I think was commended on in terms of the independent care review was the conversion of the promise into the pinky promise. So I do think taking that law and saying, even by itself, how is that going to be converted into messaging to young people, I think is really important. I think the issue in relation to the commencement date, I would probably, to use the term pushback, I think be probably highlighting that I do think the scale of legislation that we've been asked to absorb, and even if you take the 2014 Young People's Act in person to that, we probably certainly within my own service, our ability to get into the detail of that. I have responsibility for 2,000 staff over health visiting, specialist children's services and social work, I think means that the devil is in the detail. And I think even further than that, we work on an integrated basis within localities. So I think there also has to be the opportunity for key partners in terms of social work, education, health, the third sector, Police Scotland and SCRA to come together to say, well, what is, in a sense, the issues here. So I would think the 3 years for me is in a sense a kind of time frame that allows us to implement properly and implement on the bedrocky best practice, hopefully.
Thank you very much. Back to Fulton.
Thanks, Convener. Thanks to the panel for those answers. Moving on to my second and final question, it's around children's rights and wellbeing impact assessments. As a panel, what are your views on the legal duty in Scottish ministers to prepare these assessments for legislation and for decisions of a strategic nature. And I wonder as well if you could comment, if you wish, to what extent you feel that ministers should have discretion in relation to decisions of a strategic nature. Thanks.
Eddie Follen. So move to Eddie Follen first.
Okay, thanks, convener. I think we know, that child rights impact assessments and impact assessments in general now are much more a kind of feature, of service delivery. And again, as I said before, we can always improve, we can always get better, we can always do more in relation to that. So I think that Julie is absolutely right, and I would support that. And we're also, even at a local level, we're getting much better at kind of doing those impact assessments when we're designing services, and crucially, we're getting better at doing them, with children and young people as well. And again, we can always do better in that sense. I think on the second question, I think I'm going to pass on that and not make any kind of comment at this stage, but I hope that first answer is helpful.
It is. Thank you, Eddie. And now ACC Ritchie.
Yeah, I'll pass on the second question as well, if that's okay. As far as the first question is concerned, again, we have really strong EQHRIA processes in place in Police Scotland. We've done a bit of work earlier this year in the advent of the coronavirus legislation and their policies around that with Bruce Adamson in developing a process for children's rights impact assessments as well, which, as you can imagine, follow quite similar lines. So we absolutely see the critical nature of these, and I think we'll be well positioned should they become a compulsory instrument to actually build that into our policies and processes in Police Scotland.
Thank you very much. And now Alistair Hogg.
Thank you. So impact assessments are something that we've been gradually getting used to in SCRA. We have quite a significant process already in place where we do equalities and human rights impact assessments on our policies and any new processes that we're developing. So we would welcome the introduction or expectation around children's rights and welfare impact assessments, and we would see great benefits in those being applied whenever any new policy or law is being considered. They do uncover areas that you may have overlooked and which need to be considered. So we would very much support that. I would just recall some of the comments that were made in the earlier session today. The impact assessment landscape is quite populated at the moment. Equalities impact assessments, human rights impact assessments, islands impact assessments, other impact assessments that are around. So it can become quite a complex landscape. And for ourselves in SCRA, what we would like is to try and achieve a kind of overall assessment that would bring into play all of the different elements that we need to consider. The children's rights and welfare should be absolutely central to that, so we would very much support that. Forgive me, I wasn't really understanding the second question, and I'm not sure if I'm able to answer it, but could I just clarify what was being asked in the second part of the question?
Bolton?
Not Bolton's on to comment on, and that was to...
Yeah, this part of your answer there. So you're fine now, but just take it from the top.
Yeah, sorry. Yeah, it might be that you don't feel inclined to comment on it, but it was just your thoughts on to what extent you think that ministers should have discretion in relation to decisions of a strategic nature. Is that something that you feel that ministers should have discretion on? It relates to some of the evidence we took last week.
Come back in.
Thank you for explaining that, and no. Thank you. I probably won't comment on that if that's okay. Thank you.
That's fine. Excellent. And then finally, Mike Burns.
would concur with the comments that have been made about the need for the right impact assessment. It certainly seems to me, again, that it concurs with the last question about implementation, and I do think we've certainly within Glasgow and within the social work profession said, the things Susan Deacon said about in Scotland, far too much time and attention on the plan and not enough on delivery. And I think anything that focuses on the delivery, focuses on the implementation, focuses on what needs to take place in terms of promoting best practice, because at the end of the day, the issue about the promotion of children's rights is by and large by adults, and it's about how that is then occurred across adult services, and we then need to be in a position where we're able to challenge each other. So I would really agree with that. The second question, like everybody else, I think is probably not for me to comment on. Thank you.
Okay. Finally, I think that was you, Fulton, wasn't it? You didn't have any more questions.
Yep, that's me, Convener. Thank you.
And in which case, I'd like to bring in Alison Harris, MSP.
Thank you, Convener. I would like to discuss resources and costs with you. So do you have any comment to make on the potential impact on resources and the cost of this bill to your organisation, to public authorities generally, and the third sector?
Okay, first to Eddie Folan.
Thank you, Convener, and thanks for the question, Ms Harris. You'll have seen from our evidence that we do have some concerns around the resources for the bill. I think the financial memorandum I'm going to read here, if that's okay. The financial memorandum sets out a 3-year implementation programme, a £2.1 million package of funding for all public bodies to accompany it, and that's largely about training. I'm going to say again, that the 250,000 people that we have working for us in local government need to, we need to have kind of parity on this. We can't just leave this to children's services, to social work and to education. This has to be about housing, it has to be about transport, it has to be everything that, right across public sector. And I'm sure, our colleagues and police in other areas would agree. So in terms of the kind of resources, yeah, we are a bit concerned, that we would need more support really in terms of building that capacity. And we want to link the resources to the capacity. It is, however, really quite tricky to put a price tag on that. So I think what we can say is that we've had some discussions with the Scottish Government on resources. And we've agreed with them that we really need we will keep an eye on it, and we'll work together, as we kind of move forward through the implementation period to make sure, that we're getting it right. Because what we don't want to do is we don't want to undermine everything that's good about this bill by not actually putting the resources in that's going to kind of support it. So I think in that sense, we've got some concerns, but we have had some discussions, and we've had a commitment to keep talking about that and move forward that way.
Thank you, Eddie. And now ACC Richie.
Yes, thanks very much. And I should say, before I give my answer here, that it might sound a bit negative, but we're absolutely committed to working with our partners and with government to addressing these issues in support of implementing the bill in the most effective way. So it's difficult to say exactly the impact. If I take resources and costs separately, it's difficult to say the actual impact of any new legislation until we see what the detail of legislation is, and then understand how that's taken on and accepted by the public, and what that does to policing demand. But I think this bill will be significant in an awful lot of different areas. First of all, there's the implementation of the bill itself. This is going to require quite depending on the extent of the legislation, it's going to require quite a significant instruction to our officers as well, when it needs to be, because you're talking about powers, and particularly the execution of powers in relation to children and young people. It needs to be widely understood, which is going to take, I think, quite a significant instruction that might go beyond our normal training and information packages that we do for legislative change. I see it as being far more complex, for example, than the hate crime bill, and which in actual fact simplifies legislation. This, in many ways, as I've mentioned before, can complicate how a police officer is expected to act and react in any given situation. Some of the inherent tensions in the bill with regards to, just as an example, the recognition that children who will be 16 or 17 years of age have got increased maturity and increased decision making. If we're applying some of the statutory instruments as we do now to 16-year-olds, that could create a tension there, and we need to understand the detail of that and the expectation on policing and the wider legal system as to how we act. Because, as I say, our officers, when they're dealing with a child in any situation, can be considering 5 or 6 different pieces of legislation. So that's significant just in the implementation. And then, of course, there's the resultant demand. When we're dealing with cases with children, the surrounding bureaucracy, if you like, if I can just use that catch-all term, is significantly more than dealing with adults, and you would accept that, because we have to deal with other partners, and we have to share information with a wider range of partners. When we're looking at alternatives to prosecution, that brings in and perhaps addresses the question about third sectors. Again, our connections with our partners there in terms of referral and alternatives to prosecution. These are all things that are going to apply to a wider section of the community that we'll be dealing with, and therefore there could be quite significant resource demands there. And then, as before, I come on to system development, and I won't belabor the point because I've mentioned that before. So I would sum up the resource and implications are obviously going to have a direct impact on the costs. I don't think in our reading of it that the financial memorandum covers all of those at the moment, but as I say, not to be too negative, we are absolutely committed to working preparation for this to ensure that that's adequately identified and that we're well prepared for the consequences of the bill being implemented.
Thank you very much, ACC Richie. And now, Alistair Hogg.
Thank you. Can I just check that you can see and hear me?
Not presently, but
Yeah.
just we can certainly hear you, but we can't see you. But proceed anyway, Alistair, with answering, and hopefully video soon.
Thank you. So in relation to resource issue, I think we are within SCRA, we're probably in a slightly different position because our business is in relation to children and young people and the most vulnerable in our society. And we would certainly like to think that we are already compliant with UNCRC. However, as I said earlier, we're not complacent enough to think that we are fully compliant, and there may be some gaps. And what we would like in terms of resources, and I mentioned this earlier, is some form of tools that would help us with an audit of our current policies, processes, procedures, etc., to make sure that we are fully compliant, and if we're not, to understand where the gaps are. And if there are any gaps, then potentially there may be resources required to fill those gaps. But beyond that, resource implications for us, we certainly would be looking for some kind of access to guidance, potentially training as well, that would be helpful to us. And the other area, I think I may be back now, the other area of potential cost lies in the enforcement rights and the ability for challenge to be taken into court, and the potential resource implications of meeting that challenge should it get that far. But we would hope that in the vast majority of cases that court proceedings would not be required and matters would be resolved long before that, and hopefully that would be something that wouldn't happen very often. But I mention that simply because if something is of such significance that it does lead into the court, we know from our own experience, we are involved in court in our daily work, and then sometimes into the higher courts and sometimes even to the Supreme Court. And we know the costs that are involved in meeting those legal challenges. So it's just a potential resource, and it's very difficult at this stage to assess how to cost that out at this stage. Hopefully that answers the question. Thanks.
Thank you, Alistair. Finally, Mike Brown.
Yeah, I would certainly reinforce the words of Mr. Fallon, I think, in relation to our concern about the potential cost and resource. And I do think that, again, one of the things I reflect back is about we have been implementing getting it right for every child, and also got really interagency work, interagency planning. So from a Glasgow context, that then involves 2,000 staff on my part, 10,000 teachers. It includes all the police, all the health staff. So I think the issue in and around, and it isn't, I suppose, again, I would want to pick up the point about implementation. It's not just about training. It's not just about senior managers like myself saying, well, we brought somebody in for the day and they were trained on it. I think it is then about how you look at where all of that is then implemented on through your organisation, and picking up, I think, some of the points that Mr. Hoggs made about how you make sure you're compliant, and also how you make sure you're promoting as we move forward. So I do think that needs to be factored into the implementation. Thank you, Chair.
Okay, thanks very much. And back to you, Alison Harris.
Thank you. Well, I would like to finish by asking if there are any areas that you think the bill should go further to advance the rights of children and young people in Scotland.
Okay, and Eddie Fullen, first to you.
I think that I would reiterate that in local government we are other than the kind of issues that we've raised around resources, we're pretty content with the bill as it is. I think that what we do see is we see a real challenge for us, notwithstanding what what the convener said about when he kind of pushed back on because there is a view we should be doing this, but there are a lot of challenges in there, and local government public services are going to kind of have to get to grips with them quite quickly. So I know that we're working very closely with the third sector, to make sure that we can build capacity. Some wonderful work being done by the Children's Parliament. We'll be working alongside them. We'll be working with Children in Scotland and others. So, so it's not, I don't think that we need to kind of start adding things to the bill. I think we will also be advised by experts who are saying that this is a good piece of legislation as it stands, and we're quite content with that. And we have got quite a lot to do with. We've got to address, we've got the promise and the findings of the independent care review. We're going to be working very closely with them in local government. So I think that this is a really, we think this is a really good bit of legislation that's going to challenge us as it is. But again, if there are things that can be done with a bill that will improve the situation for children and young people, then we would certainly look at that and hopefully be able to.
Thanks very much, Eddie. ACC Richie.
Yes, thanks, Chair, and true to form, I'm going to agree with Eddie. I think the bill, as it stands, provides a step change, I think, for Scotland in the delivery of children's rights, and we're committed to that. I think it's correct in its intent. I think it's correct in its tenor. There are challenges that we've outlined, and we understand that. We take Eddie's point that that it's not that we wouldn't seek to add or make suggestions if we felt it was necessary. It's, I think, probably a reflection of the quality of the bill as it stands just now that we don't have anything to suggest to add.
Thank you. And Alistair Hogg.
Thank you. Yes, similar view. I think that the bill as it stands, obviously very welcome its contents. beyond what's already been contributed to your committee in these evidence sessions, some suggestions of enhancement, particularly in relation to the Children's Rights Scheme that we've already spoken about. And obviously we've already had a discussion around whether a commencement date would enhance this. Beyond that, I wouldn't have any suggestions on how it might be further improved. It is in itself just a monumental bill in terms of what it achieves. Incorporating into law is such a massive step, and I watched with some pride the contributions that you had earlier, particularly from two of the guests from other countries, about how this is perceived within the international community. So it's very commendable, and I think that as it stands, it's a really good bill that may have some areas which it could be slightly improved upon, but I don't think there's any major gap beyond those that have already been highlighted in your evidence sessions. Thank you.
Thank you very much. And finally, Mike Burns.
Yeah, I don't think I've much to add to what Mr. Hoggs just said there. I think that's a very kind of, I would concur with that. I think it's just the issue in and around implementation is the key that I would want to promote from a practice perspective and from an operational perspective. The devil is in the detail, and it is in the delivery by adults. So I would just highlight that again. Thank you. Thank you very much.
Well, that brings us to the end of our questions, and I'd like to thank the witnesses for taking part in this meeting. As with the first panel, if you've got anything you'd like to follow up in terms of your answers, you can do so in writing. We will publish on the committee's website. Can I suspend the meeting briefly just to allow the witnesses to leave, but reconvene in just a minute because we have some more business to attend to. Right, can we crack on? And welcome back. Final item of public business is agenda item 2 on subordinate legislation. It's considering a consideration of a negative instrument, the Age of Criminal Responsibility Scotland Act 2019 Independent Review of Disclosure of Information Regulations 2020. That's SSI 2020/305. Can I refer members to paper 2, which is a note by the clerks, and start by asking if any members have any comments on the SSI before us. Okay, I don't see anybody indicating they have comments, so I'm going to ask if members are content not to make any comments to the Parliament on this SSI. Okay, thank you very much. That concludes the public part of this morning's meeting. The next meeting of the committee will take place on the Thursday, the 26th of November, when we will continue to hold evidence on the United Nations Convention on the Rights of the Child Incorporation Scotland Bill. As previously agreed, I will now move the meeting into private session, and I suspend the meeting where we will reconvene shortly on MS Teams. Thank you very much.